Good morning, good morning, good morning, Law Nerd. It's good to see you. And as always, replay crew, love you. Timestamps down below. We've got a lot to talk about. There will be a lot of different documents today. What day is it? Thursday. Yikes. It's Thursday, January 16th. We have much to talk about today. Yes, the TikTok ban is still looming. We're not going to talk about it much today because really there's no further information other than the TikTok ban is still looming. That's supposed to be Sunday. The TikTok ban is still looming. So there we are. We have lots of Diddy to talk about today because there was a flurry of legal filing, a veritable flurry of legal filings yesterday. The government is big mad. They say that Diddy's attorneys violated the protective order. We've not done a court of public opinion in a minute. We don't vote on things like, is somebody guilty, not guilty? We do sometimes vote on, do we agree with the jury? Do we like how the judge did sentencing, things like that. But we don't often vote on things. We're going to talk about whether or not you think Diddy's lawyers violated the protective order once we get through everything, because I'm curious to see what you think. Nishay, don't worry. I see you in the chat. We'll do a foot update once we get past the intro. No worries. I've got you. I've got you guys in the loop. So we are going to talk about whether or not Diddy's lawyers violated the protective order. What I will say is I'm kind of torn because the docket item that we went over yesterday has been stricken from the docket. We're going to go over that. There's a lawyer part of me that's like, it's been stricken from the docket since it's been filed. It's been heavily redacted and refiled. Should I take yesterday's live stream down because that's been stricken from the docket? The other part of me is like, the media all grabbed this document the same way I did, and they reported bits and pieces of it. So is it more helpful to leave the full context of everything in that document up? And I feel like leaving the entirety of the context up is more important, seeing that every media outlet really reported on it, and I can't unring that bell. And does what's in that docket harm further the victim in this case, or does it further expose the lengths that Diddy's lawyers will go to put out salacious headlines? And I think that the second part is what's correct. And the only reason I'm leaning that direction is because of how thorough Cassie's lawsuit was. And Cassie's lawsuit was incredibly detailed. She has been vocal about what's happened and vocal about what she sustained. And because of those factors together, I think the full context needs to be up. But I wanted to let you know, I did think about it quite a lot. But we're going to go through all the arguments today. Part of that consideration is that Cassie really did put in so much information in her civil lawsuit. That is a large part of my consideration here. So I wanted to let you guys know where kind of my thought is. I think, and all of you are with me, you're like, no, it needs context. Look, the shit's out of the horse. It was not something that was grabbed inappropriately. It was not something that was filed under seal. We will talk about whether Diddy's lawyers not filing it under seal is shady. We're going to talk about it. So because we know so much about this case because of the civil suit, I lean the same way you guys do with the context is needed. Jessica Pinky Mingo, good to see you. Stricken or sealed? It was stricken. We're going to talk about that. And there is a difference between stricken and sealed. We'll talk about it. It was stricken from the docket. So it's gone. It's gone. Cannot be downloaded. It's gone. So it's gone. Glad we covered it yesterday. I suppose, because it is gone. And I agree with a lot of you. Leave it up with a note. I'll leave it up with a note, and I'll leave it up with a link to today's video. We've got three. We've got to talk about my foot. We've got three things to talk about, and then we're going to get in. There's a lot of Diddy documents. So we'll get into the Diddy documents. Law nerds, it's great to see you. Happy Thursday. I hope we're loving streaming 3 days a week. I'm loving it. Hope you're loving the Law Nerd app. I'm loving it. And it's time to roll. Let's go. Look. Oh, I meant to move my fan. I didn't. Look, it's Emily's only fan. There is Emily's only fan. It's a Dyson. Do we expect anything less? No. Why? A, she's bougie. We know this about her. But B, it's app operated, so I can start to warm up my office before I have to walk across my house to my office, which normally isn't a problem because, you know, it's not like we're living in 20,000 square feet up in here, which is not a complaint. I could never. But with the foot and the walking being difficult, it's really nice to be able to pre-warm my office. It's like being able to pre-warm your car. It's like I can pre-warm my office before I get into stream, and it's making me quite happy. So, Law Nerds, good to see you. We need to go. Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the Law Nerds unite to talk about facts, not Let's get into it.
I mean, and that's the other thing. We are here to talk about the facts, but it feels like this case, we're not just talking about the facts, like the fuckery's real. Like the fuckery's real. Okay. 3 things we need to talk about. First, thank you all for kindly asking about my foot. You are so sweet. I went to the ortho yesterday, got all the x-rays. Nothing is apparently broken. Everything is bruised all the way down based on all of the things. So it's basically being treated the same way. Yes, for all of those who are like, they don't tape toes anymore, it's a boot. The reason I'm not mad about the boot is because the pain is not the toe, it's the top of my foot and the bottom of my foot. If it was just my toe, I would have just taped my toes together like I did when I played water polo. But it was the top of my foot. And given that I am above the age of 45, and that walking weird has thrown off my knees on both sides, because goddamn, and my back, because I've had ACL repairs, I've had spinal fusions. Look, when I read Fourth Wing and Violet's talking about all of her ligament issues, I'm just like, girl, yes, because the soft tissue issues that Emily has are not enviable. So I also didn't want to throw off the rest of my body by not being able to let my foot heal. I also wanted it to heal faster. Can we just heal it faster, please? How can we heal it faster? So it really is incredibly swollen. But the boot has actually made it much easier for me to walk. It's not super comfortable, but I can walk better. And I think giving it a couple of weeks in a boot, I think will take care of it. So the foot is badly bruised. Judge Abby has sentenced the culprit. I think it was probably a due process violation when we sentenced the culprit, but do we need to see the culprit? I should have grabbed it. Hold on. I will show you the culprit. The culprit has been sentenced and is sentenced to do time not on camera. So the culprit is no longer visible because I'm angry at inanimate objects. But wheelie chair. This is the culprit. This is the culprit. This is the brass. I know I should put it on a billboard like they do in Arizona. This is the brass ampersand paperweight. I use it as a book holder because it's heavy enough to use as a book holder. So I use it as a book holder on the bookshelf. This is what wrecked my foot, and it is heavy AF. It's so cute. I know. It also fell from the shelf up there, and as I was rearranging, so it fell from quite a high height. It is quite heavy, and it landed like directly on my foot. So, but I love ampersands. I really do. Chat is like, justice for ampersand. No! Violent assault. The Assault of the Ampersand. Oh my God. What kind of Agatha Christie book would that be? The Assault of the Ampersand. So Autumn says, it says, and exactly. I know, dang gravity. It was dang gravity. Dang gravity. I need some defying fucking gravity. I've held space and everything, but no defying gravity. Oh, up in here. Gravity was just like, have fun with your feet, girl. So the ampersand is out of the way. It looks like a workplace injury. It is a workplace injury. Thankfully, I don't need to report myself to HR. HR is already aware. But I need hard toe boots. I should have had a shoe on, but I had stepped in cat throw up, and so I had cleaned up my shoes, and so my shoes are drying, and I was like, it's fine, I'm just trying to do a thing. Famous Emily last words. Emily being like, it'll be fine, it'll be fine. Mel says, Emily, it feels like you're not considering the context of why the ampersand was up there in the first place. It was framed. I don't know if the ampersand was framed. I think that someone could probably make an argument that the ampersand was pushed, and actually shouldn't bear the brunt of the weight of the derision because it was pushed, I think, by the cup. But I feel like we're going to end up with a game of Clue as to what happened with the ampersand. So it was literally framed. It had been framed in frame. So was the ampersand defending itself? It's not self-defense against my foot. My foot did nothing. It was just standing there. So, Law and Lumber is going to end up at this chat being like, do I have a new client? Yes. Actually, George is really the problem, because George was eating too fast because we forgot to put out the slow feeder for George, and he will herk down food in a way that disagrees with his digestive system. So more information than you need about my sassy orange cat, but really it's probably George's fault. Travis will fight to the death about George. So anyway, the ampersands sound like a menacing race in Doctor Who, right? You can see it. You can see it. It is. Actually, Final Destination is literally what I thought of when this happened, because I was like, because brains, but I was like, this is how people end up like stabbed in Final Destination. Like the way that everything fell, I'm like, this is how you end up with like a knife through your foot. Fun fact, I had a friend in college who had a prosthetic leg, and we would go out drinking frequently after work, and occasionally he would throw pocket knives into his foot at the bar with people that did not know. It was one of my favorite party tricks, but then I was like, but we've been drinking. So he's like, I mean, I'm not going to forget which foot it is. I'm like, but we've been drinking. He's like, yeah, but there's no fear for me that I'm going to forget which foot it is. I'm like, but it terrifies people. He's like, right, that's the best. That's the best part. I'm like, oh Lord, the things you do in your 20s. All right. I did ask him not to do it at my wedding, and I've not been told that he did. And that was 20-some years ago. So it's all fine. All right, chat. So the foot will be fine. It's annoying. It's painful. I'm not sleeping well because it is painful. All of you know what that's like. I don't need to explain pain, but I do realize I have a high pain threshold because the ortho was like, how is the pain? And I'm like, less painful than my ACL tear, less painful than my spinal fusion. He's like, I don't know if that's a reasonable measure. I'm like, well, I don't know. For me, it keeps me from sleeping well and is impacting my daily activities. Like, right, that's a problem. I'm like, that's a problem. But when you've been through too much pain in your life, your pain threshold gets skewed. Yes, it's like, you played water polo. It's like, right. It's like, coach, I broke my finger. And he's like, okay, well, now it's straight. Get back in the pool. We'll deal with it later. It's like, good. Good. All right. Let's talk about the two other thing that we need to talk about. First, let's swoop. These are not quick bits, but they are quick bits, and there will be more quick bits on Monday. But Do I think the TikTok ban is still full steam ahead? Yes. Is the company TikTok preparing to let the ban go through? It seems so. Am I annoyed that TikTok was looking at their Los Angeles workers and being like, hey, just work from home even if you're impacted by having to like evacuate and stuff? Yeah, that annoys me. Team Baker's handling of that was like, do what you need to, it'll be fine. We'll talk when things are calm. So yes, all the frustration. Did I see that V from Under the Desk News, who is also now here on YouTube? If you appreciate V from Under the Desk News, go follow on YouTube here. I think just under the Desk News. But V put out a statement from Biden that Biden said he was going to try to see if there could be a stay. I think Congress has to do it. As much as everyone wants the president to do a stay, I worry whenever presidents have signed a bill and then try to overstep what Congress wanted. Like there's separation of government that I feel kind of strongly about, but I'm kind of a rule follower in that way. So we'll see what happens. We'll see if Congress votes on a stay. But again, this has been going on for more than 4 years. So at some point when TikTok's like, we're not divesting and selling our algorithm, okay. So we'll see what happens. I'll keep you in the loop on the app this weekend. Now that I have like painkillers and anti-inflammatories, we'll be good. So I think it's all going to be okay. We'll see what it is. It's curious to me how much the app Red Note that nobody knew about, that has the same, if not more concerns that TikTok did, how that has taken over TikTok, because that doesn't feel organic to me. So here's what I would just say with all of it. Ask questions. Ask questions. Be mindful that everything in your phone can be sometimes accessed by these apps, even if you tell them not to. So be mindful. Just that's all. Be mindful. But I don't feel that the Red Note app taking over TikTok is organic. I have a lot of questions, and that's where I'm going to leave that. I have a lot of questions. Ask the questions. And whenever something that no one's ever heard of takes off, I always wonder. And this is not like a hawk to a very demure situation. I think sometimes those are very organic because it's an earworm and people are like, oh my God, I love it. Like, it makes sense to me that Heidi Montag's music is trending at #1 literally everywhere. That all makes sense to me. This does not logically make sense. So continue to be mindful. And I think my concern is that the concerns that existed with TikTok still exist. So ask questions. Rory said conspiracy theory much? No. Questions. I have questions. It does not feel organic to me. I have questions. So, whenever someone has direct control of an algorithm, anything can look like it's organic, even if it's not. So I have questions. That's all. And I'm going to ask those questions. So I have seen Duolingo. I think that's organic. I do think when people, I don't know, the Red Note becoming prolific, of course people have choice, but when everybody starts to know about a thing that they didn't know about, the algorithm gets to do the thing. I think the Duolingo stuff is absolutely organic because now people are curious. I think curiosity is good. So I think asking questions is good, but I have questions. I love Duolingo. Duolingo has lore, not only lore, but like a very sassy social media presence. So I'm just going to wait and see what happens. And we will see what happens with TikTok, but TikTok doesn't want to sell. TikTok doesn't want to divest their algorithm. Do I think ByteDance is perfectly fine redirecting everyone over to Red Note? Seems to be. So we'll see. We will see. Lydia asked, but what cursey words did you say when it fell on your foot? I think my exact words were, are you fucking kidding me? Because I don't have time for this. So I don't have time for this. That's how I felt. Second thing, and this is coming to us from Twitter, X, Bird app, whatever, because that's where some of the reporters I follow are, and it's still easy for me to follow them there. So it seems that Trooper Proctor, we should swoop and talk about Trooper Proctor. This will be in Quick Bits 2 on Monday. Trooper Proctor's disciplinary hearing is not done. It's resuming in February. So Trooper Proctor's disciplinary hearing is private. It is not accessible to the public. It is not accessible to the media. That is probably not because of Trooper Proctor. That's probably how all of those hearings are, because they are due process hearings within the police department or within the state police, state troopers. So Trooper Proctor's hearing is not done. So we will need to wait until February. Trooper Proctor's not done. So that's it. We don't know. We just don't know. So we will see. Nita said, but how will that change him testifying at the trial? Well, it will change the way a jury might perceive him depending on the action taken by the police department. Because can you imagine what the cross-examination is like after the police department has taken all those actions? It raises even more questions about how he handled things in the case. How do the, you know how I feel about this one. How do you look at everything in this case and go, let's do another trial? I don't fucking know. I don't know. I wouldn't do it. I have not yet met and talked to a prosecutor or former prosecutor who has said, sign me up. Apparently Brennan, but I'm not surprised that most of the Norfolk DA's office was like, miss me. I don't know how you retry this case. I think the trial was the best attempt, and I think you leave it there. Nothing. You just leave it there. You just dismiss it, and you just let it go. But that's also a difficult conversation to have with the victims' families. Because the conversation you would have to have with victims' families, and this concerns me with the way things are done in different prosecutorial agencies, is that if the prosecutorial agency is closely tied to the police department and helps investigate a case, it becomes, I think, more difficult to go to victims and victims' families and say, so this kind of got fucked from the beginning, and we cannot continue to prosecute this. I had the benefit of working in a prosecutor's office that worked with so many different police departments that we were not generally part of the investigation. There were times that would happen, but oftentimes something would come in for filing. And it's like, we need more information, go get it. So you're not as closely linked. So when the police do something wrong, it becomes easy to turn around and be like, this is what the police did or didn't do, and this is why we can't prosecute it. And that is the worst. And I hate all of this, but it's our ethical duty to prosecute a case that we can prove. So it's a difficult conversation, but it's not like district attorneys don't have that conversation all the time. So many cases that come in are not prosecuted. That's the way it should be. It's an uncomfortable conversation. However, you are also dealing with someone's constitutional rights. So I think the conversation needs to be had. And when the rest of the DAs in the office don't want to touch it, there's probably a reason. So it's concerning, but we won't see any more of what's going on with Trooper Proctor until February, when he comes back in for the second part of his disciplinary trial. I'm waiting to hear more about it. The lack of transparency is frustrating. Hopefully we'll find out more at the end. Fingers crossed. Emily, your optimism today is less than great. Yes. Christy said, EDB, so I can remove from my calendar reminder for Reed's trial on the 27th of January. Oh, Christy, yes, that's been rescheduled till April 1st. I'm not joking. But don't worry, we'll be back in court January 31st for Karen Reed's, for continuing hearings regarding the tech people. So that's Emily, do you have your calendar in front of you? No, but it's the hearing before whether or not there will be a Dauber evidentiary hearing regarding the defense's tech expert. It's a whole hearing about the how's long to die in the snow. Just because said, please cover the Drake lawsuit. I covered the initial filings. I know he finally filed. I will. It was not a very popular episode of the Emily Show. And I don't know if that's because it didn't get pushed by the algorithm or not, but it's on the channel. So if you search Drake on the channel, you'll find it. We can link it down below, but we did cover the initial, I think that when I said send it, and all the members that were with me when I was recording this, I said just send it, put the music in the episode. I think that really damaged the reach. Stella said, did you hear Justin? What happened to Lizzo? We need to check back in on that. Did you hear Justin Baldoni has filed again? I saw rumblings of that, but there's so much going on in Diddy that Baldoni's going to have to just wait for a minute. Also, we're all fatigued with all of these people, but Baldoni's going to have to wait a minute. So we'll get that. Liz said, I thought that episode rocked. Thank you. I did too. But when you use music in an episode, I feel like it maybe doesn't get the same reach. Like these are just my suppositions, but it is what it is. So it'll be fine. It's up there. We'll link it down below. But what we need to talk about is Diddy. And because we covered the documents yesterday, I feel that it's only fair that we cover the documents today. Also, I'm invested. Give me all the tea. And because I'm invested, we need to do the things. So do we need more lippy? Yes. But I was invested yesterday to the point that I was like, I've got to get through this document before I have to go so I can go to the doctor. I'm invested deeply. I don't know if you are too, but I couldn't not. So when I saw all these filings yesterday, I was just like, we have to do we have to do this today. We have to do this today. So I'm going to make sure nothing's been filed this morning as I pull this up too, because, well, you never know. When I checked this last night, it was fine, but one never knows. So we're going to double check for new filings before we pull up the old filings. We're going to do a brief summary of yesterday. I kind of started that at the beginning. So we'll just see. Let's see. Pacer, can you not be weird with me? Can we just log in, please? No, because Emily, you're on stream. Why would we make it easy? Jump through all the hoops, because doing things when not on stream is much easier, but that's all right. Let's see real quick. I'm optimistic that there's not, but that doesn't mean there won't be by the end of the day today. Let's see. Those we all have. All right. So let's do a swoop. Let's do a quick summary. Or a road so far, and let's get into a plethora of dockets today. The government thinks that Diddy's lawyers violated the protective order over the videos in the Diddy criminal case in their filing that I covered on stream on January 15th. That filing has since been stricken from the docket and has been resubmitted in a more redacted version. There was a fleet of filings from the government and a few orders from the court because of what Diddy's lawyers filed. Are they still fighting over whether or not the protective order should be modified? Yes. Diddy's lawyers put quite a lot of information in their filing, information that characterized the things they watched on videos that are subject to a protective order. The government is less than pleased. I imagine the victim is also less than pleased. And when I covered it on stream, the law nerds were for sure less than pleased. At its most basic level, Diddy's lawyers are saying that they need the tapes or the videos. It's all digital at this point. Emily, tapes, you're dating yourself. They need the videos that the prosecution has in their possession. They need the digital files. They said in their filing that they want to be able to distribute those to experts and witnesses with leave from the court, and they want to be able to enhance the video for audio and make the videos less dark and grainy, and they want to be able to examine the metadata. Those are two separate issues because the metadata can be turned over versus the videos themselves. The defense said it is the novel and really unusual circumstance that these types of videos need to be reviewed where law enforcement is. That's not true at all. When you are dealing with sensitive videos, like in this case, it is not unusual that those are not kept on work computers. Those are not distributed to the defense attorney. Those are made available for review. And it's often required that law enforcement make those available for review in a way where the attorneys and their client can review them and discuss them without being monitored. All those things can happen without those videos being turned over to the defense for them to have on their hard drives or devices. This is not unusual. The defense said, look, there's only case law dealing with the illicit videos or images of children. That's the only case law we have about this. Oftentimes that is extended to sensitive videos and photos of victims, like in this case. So that's where the defense is. But the prosecution is like, hey, no. Kwame said Brady rule. Yes, but do the videos have to be made available to the defense? Yes. Has the defense already had the opportunity to watch them? Yes. Has the defense already had the ability to watch them to the point that they're characterizing them in their filings? Yes. So yes, it's Brady. No, it can't be kept secret from the defense. That doesn't mean that the defense gets to have it on a hard drive, have it on a computer. There are middle grounds there, and that's what the prosecution's asking for. So we will talk about it. And to answer anyone who's new here, any new law nerds, any of you catching me live for the first time, go ahead and put a one on the chat. Any new law nerds, I will repeat myself. Federal court does not allow video or audio. Will any of this be streamed? No. It will be covered by reporters in court, and that is it. Why do the federal courts do that? Because they're the federal courts. They're appointed for life, and they don't give a fuck. They can say no, so they don't. And that's not going to change. I mean, if the Supreme Court can do audio, it feels like court should be able to do audio. Is it difficult to follow? Yes, it is. But court should be able to do it. They choose not to. It annoys me greatly. So it annoys me. I don't like it. Guess what? Not my choice. Not my choice. All right. So we have a fleet of documents. Let me start pulling those up. We have a fleet of documents to cover today because there were so many filings yesterday. And we're going to talk about all of them. We're going to get through all of it. And then if we want to, we will also pull up the protective order. If we need to go to the source, we can just go to source material if we need to. These are all letter filings, which means they are not on legal paper. They are single spaced, the way that I love to see it. We love to see it. Sarcasm. She does not actually love to see it. I hate that I can't just move this over. The way I would love to be able to pull up documents differently. We're here. Here we are. We're just here. This was filed on the 14th. It was not on Pacer until the 15th. Why? I don't know. Unless it was late. I mean, I guess it could have been late, but it was not there when we finished stream yesterday. The government says in docket number 127, Dear Judge Submarinian, the government respectfully submits this letter to request that the court direct the defendant's motion or direct that the defendant's January 14th, 2025 letter motion to amend the protective order docket 26 be removed from the docket and refiled with appropriate redactions that comport with the requirements of the protective order in this case. The motion seeks to amend to the protective or an amendment to the protective order related to certain videos that have been made available to counsel and the defendant for inspection only and not electronically produced, the videos. In making this motion with incomplete redactions, however, the defendant has violated the protective order he seeks to amend. Mm. Mm-hmm. Mm-hmm. Did they? They did put in their characterization of the videos to argue that the government is sexist, puritanical, and paternalistic. They did. They did say that. A lot. Mm-hmm. The motion seeks to amend. Oh, we did that. In making this motion with incomplete redactions, the defendant violated the protective order he seeks to amend, the government argues. The videos, they say, which depict sexually explicit content and nudity are designated attorney's eyes only by the protective order, subject to a carve-out making the videos available for the defendant's inspection. Footnote 3 of the protective order, which is redacted in the publicly filed version, specifically addresses how the videos will be made available for inspection. They're made available for inspection with law enforcement. It doesn't matter what they need in the redacted footnote. That's how it's done. This is not uncommon in these cases. Diddy's lawyers would make you think that this never happens, that the government is only doing this to him, and that's just not true at all. So they go on to say that see docket 26 footnote 8, all visual depictions of sexually explicit content or nudity will be designated attorney's eyes only, regardless of whether it has been designated as such by the government. At the discretion of the government, certain attorney eye only material depicting sexually explicit content or nudity may be made available for in-person inspection only. These are the videos. The protective order makes clear that the defense, quote, shall not share any attorney eye only material or the content of the attorney eye only material for any other person, subject to the carve-out allowing for the defendant's inspection of the video. So the defense in their motion is saying, hey, we want to provide this, not provide it to, but at least show it to witnesses. We want to show it to experts. We want to have the metadata examined, and we want the court to allow us to have digital copies, which would be digital forensic copies of the videos, so that they can be inspected. And they say altered in that they want to enhance the audio, enhance the video, but that is the type of alteration they are seeking. But they would have a forensic copy. They would not have an original copy. They would not be able to access what has been forensically downloaded and saved. So if it was forensically downloaded and saved, the defense says it was provided by the victim's attorney to the prosecution, and that's a different circumstance. But either way, saved in evidence by law enforcement. They go on to say that further, the attorney eye only material is designated sealed under the protective order, meaning any portion of such material cannot be publicly filed on the docket unless it is filed under seal or the parties first confer regarding the seal designation. Were there things in the motion we covered yesterday that depicted or described the videos? Because if so, that should have been sealed. That's what the government is saying. It goes on to say, under the protective order, no portion of the videos should have been filed on the public docket without being filed under seal or without the defense first conferring with the government as to the designation. Neither occurred. Do you think the government would have agreed to file their characterization of the victim without it being sealed? Yeah, no. Can you imagine that conversation? The government goes on to say, instead of conferring in advance or redacting all content related to the videos, the motion blatantly violated the protective order when it left unredacted descriptions and characterizations of material designated attorney eyes only. There is no alternative reading of the protective order other than 1, the substance of AEO material cannot be shared with any other persons, and 2, AEO material is otherwise designated sealed, meaning that it cannot be filed on the public docket. While the public dissemination of AEO material substantially impacts the privacy and safety of victims, filing AEO material under seal in no way prejudices the defendant, as the full substance of the motion will still be before the court. I think that's written for the public, so that there's no question. Because I don't have a question, you don't have a question. Lawyers don't have a question. If it's filed under seal, the court has it, the lawyers have it, the public docket is just redacted as to it. It doesn't harm anyone that it's under seal. The only time I have questions about things under seal is when we were getting to the Supreme Court arguments that some things weren't even provided to defense counsel. Then I have questions. But under seal in this context just means the public can't see it. They go on to say that the protective order thus serves to protect victims' interests and to prevent the defendant from, as he did here, selectively and improperly disclosing evidence to the public in advance of trial. Do you think that's what was done here? Do you think that was done here? Was it the selective and improper disclosing of evidence to the public in advance of trial? And they did it in a way that the prosecution can't address, right? The defense filed characterizations of what they perceived the victim's state of mind to be and behavior to be and level of intoxication to be, with full well knowing that the government can't respond. Because if the government responds, the government's violating the protective order. And the defense has said, the government has leaked this, and the government has done this, and the government has tainted the jury, and the government. So they filed things slamming the victim or seeking to embarrass the victim. I think it's open to your interpretation. Knowing that the government can't respond to it because the government responding to it violates the protective order. Right. So they're saying that the defense selectively and improperly disclosed evidence to the public in advance of trial, catching the headlines that they knew they would catch. The government therefore respectfully requests that the court remove the motion from PACER and all the filing from the docket and direct counsel to refile the motion with redactions that comply with the protective order footnote 2. Legal counsel for Victim 1 has advised the government that Victim 1 also opposes the public filing of information related to the content of the videos in violation of the protective order. See also 18 U.S.C. 3771 sub 8. Quote, a crime victim has the right to be treated with fairness and with respect for the victim's dignity and privacy. Was that done in the defense motion? Just a question. So the government said yeet. With this motion, the government also submits under seal, of course. The government also submits under seal for the court's review proposed redactions that comply with the protective order. After the motion was filed, the government immediately contacted defense counsel requesting that additional redactions be made in accordance with the protective order. And counsel responded only that they, quote, disagree with the government's view of the protective order. So the government was like, counsel, what the fuck? This is not how this would have gone verbatim. What you put in your motion violates the protective order. And the response was, we respectfully disagree or disrespectfully disagree with the government's view of the protective order. So the government asked defense to do this. Defense said, negative, ghostwriter, the pattern is full. So the government went, excuse me, mom, excuse me. They can't do that. Tell them to stop it. So filed to the court saying, Your Honor, we tried to fix it and now we have to bother you with it. Finally, the government respectfully requested it be permitted to file its opposition to the motion within 2 weeks by January 28th. The defendant takes no position on this request. So the government's going to respond to it more fulsomely. The government's not responding to the request to change the protective order at this point. The government is responding to the motion's statements and whether or not those statements violate the protective order. So let's see what the court did here as we pull up our next document. Give me 1 second. Because the government, not the government, the court responded pretty quickly to the government's request. So we're going to pull that memo order up. And the court calls it a memo order. You'll see why. Let's see, which docket number is that? You'll see why it's a memo order in just a second. Nope, that's not it. Where is my memo order? There it is. Because it literally is what it says it is. It is a memo order. I love it. I love that the federal judges in New York do this. It's so easy to read. So this is the memo order from the court. They literally type over the motion. So they change the motion number from 127 to 128. They change the date from the 14th to the 15th. They just overwrite it. And then they file their note. So Judge Submaranian said, granted, the clerk of court is respectfully directed to strike the motion at docket 126 from the public docket and terminate the motion at 127. So this is done. This is a resolved issue. So strike that, resolve this, it's done. Defense counsel should refile the motion with the appropriate redactions. If defense counsel refiles the motion, the government may respond by January 28th. So the court's granted, immediately granted, done. So yes, this was not sealed. This was stricken from the record, which is a lot. It's not often that stuff gets stricken from the record. The court's no, we're not doing this. So this is going to shock you. The defense responded twice. The defense filed, that was user error. I closed the wrong tab. The defense refiled the motion. I'm just going to show you. We're not going to go through the whole of it. Can we just open this in a new tab? Thank you. All right. This is the defense filing. We should probably swoop. This is the defense new filing. We're not going to read it verbatim. We already read it. This is the refiling with redactions of the filing I covered yesterday. But what you will see is that there is substantially more redactions. All of their commentary, all of their suppositions, all of their thoughts about the victim are redacted. What the government allowed in is the defense to say, moreover, contrary to the innumerable sensationalistic media reports, the videos do not depict sex parties. There are no secret cameras, no orgies, no other celebrities, no underground tunnels, no minors. However, we're dealing with 9 specific videos. That is all, 9. So it goes on to redact out quite a lot of their descriptions. They do say, and are allowed to still say, there is no evidence of any violence, coercion, threats, or manipulation whatsoever. I think that's also a characterization of the video, but I don't think it goes directly to the content of the video, maybe. But it seems that when the government said, these are the redactions we want you to make, that the defense did that. I don't know if they're still going to fight over some of these other statements. But there is substantially more redaction than there was. And the headlines that were grabbed from this, the headlines that were everywhere from this, and the conversation about it, all of those things have been redacted. So there is quite a lot of redacting in this, quite a lot more than what was in item 126 or docket 126. But the defense isn't pleased, and they responded more as well. So we're going to go through the defense motion on that because the defense had more to say. So let us go to what the defense had to say because they're not happy. The defense is not happy. Just because said, isn't the damage already done? I do think there's a level of you can't unring that bell. However, it also notes that what the defense did, it should not have done, but there's going to be a fight over this too. The defense is not done fighting. I also, again, if this had been a different case, I probably would take my video down, but because so much of it is detailed in Cassie's civil suit and we've been through that pretty thoroughly, I'm not going to take that down because I think full context beyond the headlines is appropriate. And people and Us Weekly and whoever else covered it aren't going to take theirs down. So I feel that mine is a supplement to what was filed by the defense. So, or a supplement to what was covered by the media. That's the right way to say it. So that's what we're doing. Are we keep lip glossing? Yes. For everybody who asked, is this Clinique? Yes, it is. This I wore like all through junior high school. The way I'm so glad that it's back, it feels like finding an old favorite book. It really does. I'm so excited. So we are going to docket 130 because the defense objects to the government objecting. This feels like I'm mad because you're mad. So you don't get to be mad. Has that ever happened to any of you? I'm sure it has. Where you're just like, hey, these are the things that bother me. And it's like, I'm so mad that bothers you. And then you end up in a fight over who's mad and allowed to be mad. That's what this feels like. It's I objected. I object to you objecting. Objection. All of it. Yes, Steve said, yeah, offended because I'm mad. Exactly. It's offended because I'm mad. It's like, I can't believe the government even said that. So let's see what the defense has to say. Again, this was filed yesterday, January 15th. So January 15th, 2025. Judge Submarinian. Listen to what they did. Listen to what they did. We write in response to the government's letter requesting, I've got to shift my chair so I can put my leg up. We write, sorry, I'm shaking my desk. If the camera shakes, it's me because I'm wiggling to get my foot up so it doesn't have its own heartbeat. We write in response to the government's letter requesting redactions to the defense's January 14th letter motion, see dockets 126, 127. At the direction of the court, this letter motion has been refiled with the government's requested redactions, docket 128, 129. Nevertheless, we write in opposition to the government's proposed redactions as overbroad and inconsistent with the presumption of public access to judicial documents and seek leave to refile the letter motion with the narrower redactions. Remember, the defense wanted more protective orders and gag orders when they wanted them. So now they're like, As an initial matter, the defense's general characterizations of evidence did not disclose the content of the attorney eyes only video. Did it? Did their characterizations, did anyone believe their characterizations of the videos? I guess that's a big question. But they're saying that their characterization of the evidence, and they're admitting that it is a characterization of the evidence, does not disclose what's in the videos. Does it? Does it not? I think there's a solid argument. I don't think the government's missing the mark here on whether or not they're saying it discloses what's in the video, because they are characterizing the victim's behavior on the video, their perception of the victim's participation. level of intoxication, etc., etc. So is that characterization describing what they saw in the videos? I mean, it's not describing physical actions, but it is describing overall perception. And is that a problem? So it definitely paints a picture of the videos different than what the government has said. But then again, the government made a lot of those arguments before the protective order went into effect. So, a general description I saw. Jesse said the defense objecting to the government's objecting, so they're playing Exploding Kittens and got into a no card war. Jesse, yes. And for everyone who's played Exploding Kittens, they know what we mean. I love playing Exploding Kittens with the family. Except for my mom, because I swear to you, my mom will come into a game and be like, I don't know the rules. And then she'll just destroy everyone. I think she just lies to us. It's wild. She's like, I mean, I don't even know how to play this. And then we all lose. And we're like, what just happened? She's like, I don't know. My mom plays innocent so well. She's like, except for Uno Attack. Uno Attack has no chill. And there's no gamifying Uno Attack, though she tried. She's like, what? I pushed the button. If you've never played Uno Attack, by the way, Uno Attack is so much fun. Uno Attack is so much fun. Just Uno Attack is so much fun. I need to put it in my Amazon store. Uno Attack is so much fun. And chat, I've seen a lot of comments to the point that Miguelina has also let me know that there are new filings. Do I have time to get to new filings today? Probably not. If we do, we'll see. But look, if people file things while I'm live, it's not on me. The lawyers should learn by now. I go live at 11 a.m.-ish Central Time. Send me a heads up. But they don't. They go to the other media outlets. So if we do not have time, and I don't know if we will today, if we do not have time, we will get to it on Monday. If we have time to take a quick peek, we will get to it today. I will see what we can do. I do have a hard stop today because I have another appointment. But Uno Attack is so much fun. I haven't played Uno No Mercy yet, but I need to. Uno Attack is amazing. So it's amazing. James said they really don't respect our schedules. I know. Like, if you want the most impactful legal coverage, you don't loop in TMZ. You loop in EDB. That's all I'm saying. That's it. So I mentioned it on, and if you guys are on Instagram and following the Spencer Pratt, Heidi, everything, I did comment on one of his videos where he was saying that he's going to be suing a whole bunch of people. I'm like, just loop me in on the lawsuits. If you see that on Instagram, just like the comment so he knows. Like, just loop me in. I should just text Heather McDonald. Be like, Heather, send me the lawsuits. It's just, it's helpful to have a heads up. Everybody else gets one. So, Miguelina, yes, thank you. Let's continue on with what the defense is saying. And if we can zoom, we will zoom. That would have to be with the chat understanding that if we can't get to all of it because we have a hard stop, that's okay with you. So when we get to the end of this, I'll put up a poll and see what we can do. So they say that the defense characterizations of the victim in the videos does not violate the protective order because it does not disclose AEO material. Again, attorney eyes only. I'm not going to keep saying attorney's eyes only. I'm going to say AEO. A general description of the nature of the evidence with specific descriptions and additional details redacted is perfectly consistent with the language and spirit of the protective order. Your Honor, vibes. Your Honor, vibes. Diddy's a feminist and the government's kink shaming him. It's just... This is especially true when the evidence or the existence of the evidence is already public and the government has regularly provided its own characterizations. CEG, let me know if this argument's well taken to you. CEG, indictment 12A, publicizing extended sex acts with male commercial workers. However, the indictment happened prior to the protective order that the defense asked for. Aaron, this is a good point. Where does the hotel video fall into the kink shaming? I would go further, Aaron, and say, where does the hotel video fall into consent? Because Diddy's attorneys are out here like, hey, this is a consensual relationship. Yet, it seems that at times when Cassie tried to leave, that was not permitted. You know, AK, maybe I'll just share it on Instagram after this. You know, just a question. That's true. I'll share it. One Nippy Hippie said, which one? I'll share it. Bookworm said, started watching Traders last night because of you. I hope you enjoy it. It's time well spent. So they say the government characterized these things in the indictment. The indictment preceded the protective order. What I want to know is, did the government characterize these things after the protective order? And the answer is no. Docket 5 is before the protective order. For all of you playing along at home, docket numbers go in order, and the protective order is docket number 26. So unless we're docket number 27 later, then we're there. So, you know, they go on to say docket 5 at 12, publicizing that during freak-offs, alleged victims were subject to physical, emotional, and verbal abuse. I will also add that if the government did not put those details in there in the indictment, the defense would make a motion to dismiss, saying the indictment does not sufficiently detail the crimes that are being charged. And in fact, the defense has already argued that the government has not gone into enough detail, and they essentially asked for a bill of retainer for the government to spell out their case even more. So there's both. Even assuming the defense's general characterization of evidence without additional detail is covered by the protective order, which it is not, they say, that is, quote, not a valid basis for sealing. The protective order is a court order. The court order says it must be sealed. You don't get to then not seal it now because you feel like it. Those are the rules of the game right now. If you want the rules changed, you file the motion to change the rules, which is exactly the stage we're at. The government just said, but you can't break the rules when you're asking for the rules to change. You have to wait for the rules to change. You don't get to just break the rules. This is court. I don't know what you do in other courts, but you can't do this in this court. So let's continue on. In determining if a docket should be publicly accessible, the court should, 1, determine if it is a judicial document. Look, stop it. None of this matters. The court has a protective order in place that requires sealing. Unless the court changes that order, none of this matters, because the court's not going to do this balancing test. Did you follow the protective order or not? This evaluation is unnecessary. This has already been done when the protective order that both parties agreed to went into place. So they are now saying the court should do all these things that the court doesn't need to do unless the court changes the protective order. This is going to get missed by non-lawyers that read this. They're going to be like, the court didn't even do that. Well, no, that's not true. This is not a defense team that the media is going out of their way to bend over backwards to treat graciously, I would suppose. In determining if a document should be publicly accessible, the court should determine if it is a judicial document, determine the weight of the presumption of access attached to it and balance the countervailing interest against the presumption of access. None of this applies in this circumstance because there is an ongoing protective order. This balancing test does not apply. All of this can be stricken from this document. It'll just line it out. There can be little doubt that the explicit Sixth Amendment right of the accused is no less protective of a public trial than the implicit First Amendment right of the press and the public. Again, protective order. Because the motion to amend, now we're back on topic. Because the motion to amend the protective order is, quote, useful in the judicial process, the presumption of public access applies to the motion, not to this objection. It applies to the motion. So if the protective order is changed, then you can make this argument. But the protective order is not changed yet. Until it's changed, this argument doesn't apply. That's how I see it. They go on to say, this is the right of public access. But Your Honor, the public. I'll be on your side arguing public access when you start arguing for cameras in this court. For now, I'm not here. Blueberry Smoothie followed the number one rule of Emily Questions, follow the money. Blueberry Smoothie said the only person happy with this document is the lawyer who can charge those billable hours. At the end of the day, generally the only winners are the attorneys. Those billables, by the way, nightmare fuel. I don't ever want to do that. Not my world, not my gift. But for the attorneys that love them, this case is a gold mine of billable hours. Same, Jay-Z's lawyers are billing the exact same way. It's like, we can file it, we're gonna. They go on to say this is especially true. Because the motion to amend the protective order is useful in the judicial process, the presumption of public access applies. Not till later, as I see it. This is especially true, whereas here it relates to the government's key piece of evidence and Mr. Combs's trial rights are being compromised by his inability to access this. This is not even an objection at this point. This is rehashing what was in the last motion. We're just going all Morrissey on this. Kerry, not the Massachusetts one. And I said that because the first name escapes me. We're just now rehash. This is not an objection to the government. This is now just, but I said we need the protective order revised because the trial rights are being compromised by his inability to access it. You have access to it. It might not be easy access, but you have access to it. They go on to say, indeed, the public can only have confidence in the conscientiousness, reasonableness, or honesty of judicial proceedings if the documents on which judges rely are publicly available. Thank you, chat. It is Michael Morrissey. I appreciate it. No, Michael. Not without cause. That meme has been coming up a lot in the reels that I watch relating to books. So, Your Honor, the public needs to have confidence in the conscientiousness and reasonableness of the documents on which judges rely, and they can't possibly do that without our somewhat salacious and specific depictions of how we perceive the victim in this case. How could they ever know what our legal arguments were without all the details in which we included? How would they know if the government was really paternalistic, sexist, and puritanical if we didn't tell you how empowered the victim is in the videos that we saw? We need this information. Thank you, Ashley McQuirk, who said, I do have cause. It's because I hate him. They go on to say the presumptive right of access prevails. Your Honor, the public needs this information. The presumptive right of access prevails unless it is overcome by specific on-the-record findings that sealing is necessary to preserve higher values, and only if the sealing order is narrowly tailored to achieve that aim. You already agreed to a protective order. It lines out what documents are to be sealed. That's already done. The court doesn't need to evaluate it here. Until the protective order is modified, all of these arguments are moot. They go on to say, notably, generalized statements regarding sexual activity and privacy interests are insufficient. All of these arguments, and the reason I will stop harping on this is because now you know, all of these arguments don't apply at the moment because there is a court order standing. If there was not a standing court order that already lined out when things were to be sealed or not sealed, then you argue these things. Your Honor, this shouldn't be sealed. The government's asking to seal it. Here, the government's not asking to seal it per se. The government is asking the defense to adhere to the rule that's already been established in a court order, saying that this is what gets sealed. And until that's modified, I don't think they can file it. They are saying, well, change it. But all these arguments are just, I don't know. These are not well taken by me. They say the government's letter fails to address these issues and fails to provide any valid justification for sealing that would override the presumption of public access. They didn't have to because there's a protective order that says that it gets sealed. They don't have to argue for a new sealing. They're arguing for you to adhere to the court. And the court agreed because the court said granted. This is not a new evaluation. There's a lot of rehashing. Lyndon said, this is a lot of words to say we don't like what we agreed to follow. 10, yes, 10 out of 10. Moreover, any competing justification provided by the government would not outweigh the presumption of public access to justify sealing. While victim one may have privacy interests that justify keeping the videos themselves under seal at this stage, including details of the content of the videos, the fact that victim one was filmed while participating in the so-called freak-offs is public information. Indeed, the government has publicized that these were, and I'm not reading it again, notice that those are in docket, those are paragraph 12 of the indictment, docket number 1. The sealing order was docket number 26. They go on to again put what is in the documents. As I said, no, they have gone on to copy and paste what was in their last motion into this motion, faulting the defense for characterizing that same evidence as exculpatory and consensual is an unfair double standard. Docket 1 and docket 5 existed before docket 26. Then docket 26, and now you have to follow the rules or ask to change the rules. And they're asking to change the rules. I have to wonder, cynically, if the reason that they put in what they put in and didn't redact it, because the damage is done, if the reason they put that in there is because they don't think that the court will modify the protective order with regard to what is sealed or not sealed in the public record. So they go on to say to accept the government's broad reading of the protective order would turn it into a tool to shield the public from any interpretation of the evidence that could be favorable to Mr. Combs. I don't think that's what it says at all. I think the defense could have said, we need the protective order to be modified so we can access the videos that are the core of the government's case. We need to make those videos available for experts to do these things because we believe those videos are exculpatory, and we have reviewed those videos and see that the audio needs to be modified. We need the metadata. We need to see if we can enhance the videos for our own review, and we need to use them in this way because we believe they are exculpatory and they undermine the core contentions of the government's case because they do not purport to show what the government says that they do. That argument is completely fair, completely allowable, and completely accurate. Kwame, I answered this once. I'm going to answer it one more time because this you've continued to put this in the chat numerous times. This is not a correct interpretation of Brady. It is not against the law for the government to make them available the way that they have. As I answered earlier, even if it is potential Brady material, it doesn't mean they have to turn over full digital access. They have to make it available. Those are two different things. And here they have made it available. And we saw that because the defense has reviewed it enough to characterize it in motions, and they said that they have reviewed it. There are many cases where not everything gets turned over in hand to the defense. It can be made available. In a narcotics case, the police do not take a baggie of meth and give it to the defense and say, here, you can go test this with your experts. But if the defense attorney wants to go and see if the baggie of meth is as characterized, they can go to the police department, have an officer check it out of evidence, and show it to them. They can have the police department send it to a private lab and have it tested. They can do all of those things, but they can't have it in their office. They don't get to keep it. So physical evidence and digital evidence are the same. And yesterday I made this example with regard to a car. If a car is central to a case, the car doesn't get given to the defense. The car is at either impound or the police department or a police department sally port per se. And the defense can go view it. The defense can bring experts to it. The defense can download data off of it with their experts, but they can't take the car to their office. There are lots of times that physical evidence is made available for inspection, made available for review, but not physically given. Pigeon Business says, so if you get stabbed, you don't get to keep the knife. No, it's not fourth wing. If you win, you don't get to keep the knife. You can go inspect it at the police department, but it's the same with guns. If a gun is part of evidence, the defense attorneys don't get to take it to their office. They can bring experts to the police department. So this is not different than other types of evidence. It might feel different because it's digital, but this is very common in cases where the digital evidence is of a very sensitive nature. That is the case here. That is the case with CSAM material. That is the case with other types of material. So hopefully that has answered it twice. And for everyone who came into the chat after the time I answered it, there we go. But no, they do not have to give it over. There was a time I went because counsel wanted to review literally meth. That's why I use that example. We went to the police department together, and the defense attorney started poking on it in the bag to like break up and I was like, counsel, you can't touch it. What are you doing? The police were like, you can't do that. And he goes, well, in the report, it says it was this many noticeable pieces. It's like, I watched you poke it with your fingers. Come on, counsel. I was so mad. It's like, you can't touch it. Stop it. You can't modify the evidence. Oh, so that's where we're at. It is not improper for the government to do this. It is not unusual for the government to do this. So, and you can disagree with that all you like, but in that case, it is just wrong. Yeah, I was like, I was looking at the defense attorney. I'm like, you've got to be kidding me. But right now you're just like, poke, 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 poke. I was like, what? You can't, no touchy. No touchy. All right, continuing on. To accept the government's broad reading of the protective order would turn it into a tool to shield the public from any interpretation of the evidence that could be favorable to Mr. Combs. I don't think that's true. I think I gave an example of how to argue that. They say the result will be an unfairly polluted jury pool manufactured by the government's misleading narrative and widely disseminated by the press. Question, chat. Question. Is that really what they wanted here? Just you tell me. Is this really what they wanted? Is what they really wanted was for the narrative to not be misleading? Is this what they're filing? Is this the heart of their filing? Are they saying the quiet part out loud? That, Your Honor, if I'm not allowed to file this, then the jury pool will be polluted by the government's interpretation. I need my interpretation out there. Is that what the defense wanted in their last filing? Your Honor, it's going to be widely. You guys are like, no. Your Honor, what the government has said has been widely disseminated by the press. Our side needs to be widely disseminated by the press. It's like when you get defense attorneys who are like, hey, can you bring the weapon into court? And then everybody gets real nervous. And then they have an expert on the stand waving it all around. These things don't always go well. I think that's the quiet part. I think that's what the defense wanted. The result will be an unfairly polluted jury pool manufactured by the government's misleading narrative. Your Honor, we have to have our own narrative that's widely disseminated by the press. Maybe I asked they wanted it polluted by their interpretation. I think they wanted to share it, right? They're just regretting the gag order they asked for, maybe. So, we appreciate the court's consideration. Thanks, Your Honor. Let us file it. Again, we'll see what the court has to say about this. Shit's already out of the horse. The government has to file their objection or their response to the motion by the end of the month. We'll cover it at the end of the month. We'll see what the government says. At the end of the day, here, let's do a quick summary and then we'll decide what we're going to do next. At the end of the day, the defense has said, hey, Your Honor, we've complied with the court's order. We have filed a substantially more redacted version, but we think it's unfair that we have to. And we think it's unfair that we have to because if we have to do that, the result will be an unfairly polluted jury pool manufactured by the government's misleading narrative and widely disseminated by the press. They say that their characterization of the evidence that they've reviewed is appropriate, that it should not be sealed, and that the court should evaluate when something is proper to be sealed and that public access reigns here. I disagree with the defense argument on this because the protective order, including the sealing order, is already in place. The defense, I think, has properly asked that that order be modified the way they want it to, and then the court gets to decide. But you can't file things not under seal that contradict the protective order when you ask to modify the protective order. You have to wait for the protective order to change. The defense says that the government reading of the protective order is too broad, and therefore they should be allowed to have their original docketed item stand without all of the redactions. We'll see what the court does with that. This is going to go to hearing probably in February, and we'll see if the court modifies the protective order then. Because with that, we're going to have to wait and see. If the protective order is modified, it might not change the sealing order. If the protective order is modified, it really, the heart of what they were asking for is to allow them to have digital, physical, allow them to have digital, physical access to the videos at question. Here are 9 of the videos that have been identified. They want to be able to have those videos enhanced, have those videos enhanced for audio, shown to expert witnesses, evaluate the metadata, talk to other witnesses about them. They want access to those videos. They not just inspection of the videos. They want the videos to come to them instead of them going to the videos. And we'll see what the court does with that. But the court can do both. The court could say, yes, under protective order, you may have access to these videos, not just inspection. And the sealing order stands, you still can't put this in your filings. We will see what the court decides to do, probably in February. But again, when I say this trial is right around the corner in May, this trial is right around the corner in May. Dealing with digital experts is not a swift process, so I still don't think this will go to trial in May. I really don't. All right, chat. Here's where we're at. I was going to leave extra time for questions today. That was my goal. But all of you have asked about a new lawsuit. It's also my understanding from chat that it is about, 1,000,000 pages long. We can do a overview. I've got about an hour to do an overview. I've got a hard stop, but I've got about an hour to do an overview. It's not going to be a full deep dive. We're going to have to change the thumbnail. We're going to have to change titles, but I'm going to put up a poll. What next? Let's see. Quick overview. Time for questions. All right, I'm going to ask you guys. Not Drake today. Drake is going to go in quick bits because I've already covered Drake and we knew kind of what would be in that. But I do have a hard stop, which means I'm not going to get to a lot of questions. If you guys are cool with it, we'll let the prevailing wisdom of the chat roll. Let me take a look because I need to get my hands on documents. Let's see. So we need to get to documents first. This was filed when? Today. So there we go. Thank you, Miguelina. And thank you to the mods and everyone who grabbed this immediately. Let's see what the poll says. The poll's like quick overview. All right. For those of you that are like, what are we doing? Justin Baldoni, Wayfarer Studios sued Blake Lively, Ryan Reynolds, Leslie Sloan, and Vision PR today. And we can do a quick overview. We know a lot of it's going to be redundant. So the Blake Lively case, the poll has spoken. Miguelina, do you want to work on a new thumbnail? I feel like we need to update the thumbnail. And maybe if you want to, before you do that, Miguelina, will you just nudge the app crew, and let them know that we are going to quickly cover the brand new lawsuit. Do that first. And then we'll go to here. The poll's just like, fuck yeah. Let's look at let's use the time we have. But I do have a hard stop today due to an appointment. So we're going to do the best we can in the time that we have. And you guys are like, that's better than nothing, because I have appointments tomorrow too. So would I otherwise stream again tomorrow? I mean, this week we've already been like, today will be a shorter stream 5 hours later. Last week I'm like, hey guys, welcome back. I'm going to try not to do this in 8 hours. Did it in 7. Like, it's been a lot of streaming. And we've got court coming up. But all of you are like, hey, we understand if we don't get line by line, but we want to look at it. We want to ride. We want to look at it some, even if we don't have time for it. All right. And then I will keep you posted in the app this weekend as things change with TikTok in notifications. If I record stuff on Instagram, I'll link it in the app as well. All right. All of you are like, let's ride. 179 motherfucking pages. Have I read anything about this? No. Do I know what they're going to say? I can guess. All right. Are we going to talk about this more in quick bits? Yes, we're going to talk about this more in quick bits. So let's do that. All right, chat. Let's do a swoop. No, we are not doing a swoop. You know what we're doing? We are doing something that we do not do often, because normally I say no. But let's see. We do have a new filing. I don't know if I moved my new filing bumper. I might have. Moved my new filing bumper. Where did I think I did. I think I accidentally did. So we are gonna do a swoop. It is rare that we have a new filing that we cover on stream, because normally I don't cover things out of the blue. But it's a case that we've been covering, and we knew this was coming. I did. Thank you, Melina, because I was like, no, we don't cover things on the fly much. It's all right. We'll just, we're going, well, we were in New York, but we're going back to New York. For those of you that want to tag my producer, Tech Valor, and tell her she's the best, her handle is Tech Valor. So today, Wayfarer Studios, Justin Baldoni et al. Seemingly has followed through on their promise to catch a lawsuit for everybody. In the last filing that we covered with Baldoni, Wayfarer et al. Versus the New York Times, they said, quote, "Rest assured, this will not be the last lawsuit. We know that the attorney for Wayfarer, Baldoni, and everyone, Brian Friedman, has repeatedly said in the media that he will be suing Blake Lively directly and into oblivion or something of that nature, that he will be suing Ryan Reynolds and others. He basically was like, I am the Oprah of lawsuits. You get a lawsuit. You get a lawsuit. You get a lawsuit. I am not surprised. I have not reviewed this. It was filed today, and it looks like all the media reports about it came out as we were getting ready to stream and started streaming. So I expect that this will largely cover what we've already seen, that the allegations will largely cover what we've already seen, and this will further divide an already divided public in a case where we don't have nearly enough information to really know what the fuck is going on. Or at least I don't. I don't know what is going on. We have a lot of allegations. We have a lot of shade. And I am waiting for all the information under the allegations and shade. And it's going to take some time for that to come out. But people are already steeply divided about this issue based on who they like and who they don't like. If you want me to mirror your feelings on who you like and who you don't like, I guarantee that you will be disappointed. That is not what I am here to do in this case. I want to see if we can parse through what happened. Oftentimes in lawsuits, multiple things are true at the same time, and there is going to be a lot of gray zone between the allegations, shade, and where this lawsuit ends. Do I know who's right and wrong here? No. Is it my place to judge who's morally correct in any given situation at this point? No, we don't have enough information. We have lawyers lawyering and working quite hard to paint public perception one way or the other. Does that mean these lawsuits, good, bad, and different? That I'll tell you about. What information needs to be in a lawsuit? What information is maybe extraneous detail? What information is shade? Yeah, I'll tell you all of it. Are we picking sides here? No, because we don't know. And I don't, definitely as an attorney, know enough. So I would only ask that you try to keep an open mind. Whoever you like, whoever you don't like, whether you give a shit about any of these people, try to keep an open mind. We don't know yet. And try to evaluate the lawsuits as we cover them. What I have seen largely in the comments is when I am questioning the side of someone's favorite, they're like, you're so biased. It doesn't matter which side that is. I'm going to question all of the lawsuits, no matter who filed them. That's what I do. Question everything. And it's okay if you're like, I don't like any of these people. I just want to see what's going on in Hollywood. That's where I'm at. If I am team anything, I'm team explain to me the inner workings of all the Hollywood PR. It is so far from my normal world of operation, and I am so curious. So if there is any confirmation bias for me, it might be, is this all fake? Do we even think what we think? And how do these PR campaigns operate? And is that illegal? Is that violating civil causes of action? Is that falling in a gray zone? Do the laws well accommodate the manipulation of social perception or not? Is that defamatory? Is that retaliation in a workplace? I've got so many questions about how the law is going to address all of this. And this is going to be a case where legality and morality might diverge, where it might be like these tactics are gross. That doesn't mean that they violate civil tort law. I'm very curious about Blake Lively's employment suit and how that goes forward in California. Is a alleged social media perception manipulation campaign workplace retaliation? And is that different than maybe an employer who you complain to calling others in your industry and saying, don't hire them? Is that retaliation? And is this similar to that, where you raise a concern in the workplace and then you find yourself out of an entire industry because the heads of the industry have all had that conversation? That's generally retaliation. Is this the same? And it's easier, I think, to prove a phone call. Hey, this person caused a lot of problems, don't hire them. Those problems being complaining to HR about shit that shouldn't happen in the workplace, if that's true. Is that the same when the workplace is Hollywood in the public as a contrived, if proven, social media campaign to make it so someone can never work in this town again? Are those two things the same? I don't know. Are we going to find out? Yeah, I'm real interested into how the law addresses this. How does the law deal with very new, nuanced, and not clear-cut situations? And what happened on this movie set? I don't know. What I do know is that I want to understand, and right now I'm not at a place where I understand enough. I've seen a lot of allegations, but I'm not anywhere. There are cases I have strong feelings about, I'll tell you. My feelings here are pull back all the curtains and let us see what the fuck's happening. I'm team, let's ask questions, let's get curious, and let's see what they're saying. So for today, the trilogy, oh God, what's next when there's 4? What's next when there's 4? Tell me, what is next with the 4? The trilogy has expanded into prequels. Exactly, for everybody going, let's get dangerous. Quartet saga? A saga, a quartet? I mean, I don't know. Maybe we are now at a saga, a quartet. But we're now at the 4th lawsuit. We have, the road so far is, we have Blake Lively filing a complaint to the California Civil Rights Board that was provided to the New York Times, who then wrote an article all about what happened, they say, on this movie set. We have Justin Baldoni, Wayfarer et al. Suing the New York Times over that article for defamation. This first one is a administrative action so far. We have Jones Work PR really spilling all the tea and pulling back all of the curtains on what was happening with PR from their perspective. Curious to see. Jones Work PR sues all the PR people and Baldoni et al., saying, Baldoni et al., you violated your contract. This is an employment contract. That's where all the text messages came from. Whether that was proper or not, I guess we'll see. Then you have Blake Lively suing in New York federal court, similar to what was in the complaint in California. We've not broken all of that down yet. Now we have the 5th filing, but 4th lawsuit in the saga. We now have, as of today, Wayfarer Studios, Justin Baldoni, Jamie Heath, It Ends With Us Movie LLC, Melissa Nathan, and Jennifer Abel suing as joint plaintiffs Blake Lively, Ryan Reynolds, Leslie Sloan, and Vision PR. So Blake, Ryan, and their PR agent are all getting sued in federal court in New York. Interesting. This was not filed as a cross complaint to Blake Lively's federal court. That's not helpful. This was not filed as, where did my document go? User error. My apologies. It just completely, that might be server error. It just completely crashed. All right, you guys, let me pull this back up real quick. The dramatics, the anticipation, that was not on purpose. That was just me. So did my mouse just decide to stop working? No, everything's going smoothly. Technology and I are best friends. So my computer's like, girl, you have too many tabs open. Have you met me? Have you met me? So this is everybody. And let's see what the general allegations are. Let's see what they have to say. And then let's reshare this screen so we can see the lawsuit without everything being frozen. There we go. There we go. Let's take a look. This is not filed as a cross complaint, which is what I was starting to say when everything got discombobulated. This is not filed as a cross complaint in Blake Lively's lawsuit. This is filed as its own lawsuit. There will be, I'm sure, motions about whether those two things should be consolidated or not, but these are different plaintiffs and different defendants, and joinder can get complicated. So does that surprise me? No, not at all, but a wholly new lawsuit, Batman. Plaintiff Wayfarer Studios sues everybody. Great. You know, these lawyers do write well for the public. The following is not a story plaintiffs ever wished to tell. Oh my God, it's written like the opening of a Netflix drama. Let's see. I'm live now. Sorry, I was just getting a text about my phone has blown up during this. So the following is a story of the defendant's greed. The following is not a story plaintiffs ever wished to tell. Unfortunately, defendant Blake Lively has unequivocally left them with no choice, not only to set the record straight in response to Lively's accusations, but also to put a spotlight on the parts of Hollywood that they have dedicated their careers to being the antithesis of. The task was always going to be an uphill battle. They never imagined they would encounter it to this degree. Well, that is the opening to a Netflix doc. That is what it is. That is what it is. Did the screenwriters get a credit on this? I just want to know. Look, back to Are You Not Entertained? The drama. I said this, I think, on today. I think the Vile Files drops today, where I said Baldoni's lawyers are going to say that Blake started it. I said it today. We recorded it yesterday, but Baldoni's lawyers are going to say that when Blake gave that complaint to the New York Times, she started this. She asked for this. She brought this directly to her door. That's what they're going to argue. She brought it to her own door by saying, or by giving that complaint to the New York Times and by giving those texts to the New York Times. I said that's what they were going to say, and here we are. Had Lively chosen to merely ride out the self-inflicted press catastrophe she faced in August 2024, the public would likely have moved on and never known the truth about her. They would have never known that she deliberately and synthetically robbed plaintiffs Justin Baldoni and Wayfarer Studios of their movie. No one expected the parties involved, or no one except the parties involved, would have known that she used threats and extortion to relegate the colleagues she once highly praised to a basement to sit out their own premiere while she enjoyed the spotlight of a premiere and after party that was ultimately co-financed by both Wayfarer and Sony. I want to hear from Sony in all of this. And that's what I want to hear. Drea said, or he started it with his behavior. Yes, when I said Baldoni's lawyers will say, yes. This is what Baldoni's lawyers were always going to say. I want to hear from Sony. But yes, Lively's going to say, look, we know what Lively says. Lively says what the New York Times said. We can bury anyone. Lively's side said in their complaint to the California Civil Rights Department that there was harassment on set, that there was sexual harassment on set, that they wouldn't resume filming until all of those things were addressed. Once they were addressed, we went forward. And then there was they say, social media smear campaign to destroy Blake Lively. So Lively said, no, they started it with their social media campaign. We had to set the record straight. Baldoni's team said, you should have just ridden it out. Now we have to set the record straight. It's going to take us a while to get to the bottom of that. What's organic and what's not on social media? That's really my biggest question at this point. That's my biggest question. What was organic and what was not? And what was the interneting and what was not? So both sides are going to say, you started it. They go on to say she deliberately and systematically robbed plaintiffs of their movie. I want to hear from Sony. No one except the parties involved would have known that she used threats and extortion to relegate the colleagues she once praised, to sit in a basement during their premiere. She would have gotten away with these things and more because Baldoni focused entirely on seeing the movie succeed. Remember, this is going to be from the light most favorable to them. This is going to be the Baldoni is an altruistic guy, and Blake came in and bullied him and stole his movie. Blake's side is, that's all bullshit. This is what happened. And we haven't heard a lot from Blake's side about the takeover or not takeover of the movie. I still have a lot of questions about that. They are saying Blake would have gotten away with these things and more because Baldoni, focused entirely on seeing the film succeed, would have held his tongue. And as he had through the year and a half that Lively tormented him, his family, and his partners. But Lively could not tolerate her publicly tainted image for even a moment, and further could not accept that it was entirely of her own making. She needed a scapegoat. And rather than admit and take accountability for her own mishaps, she chose to blame plaintiffs in a malicious and unforgivably public manner. This is a lot of paragraphs for Your Honor. She started it and we are forced to respond. How are you bringing Reynolds into this? That's what I want to know. Shelley Mack in the chat said, you started it, did too. Chow Yun Smut said, both sides are basically no you. When she and Reynolds could not force Baldoni and Wayfarer to read a statement she and her representatives prepared, extorting them to take accountability in defense of Lively's actions, she lay in wait for months, preparing to publicly attack Baldoni by falsely claiming that he had sexually harassed her. Again, she says that that's not true. He says that it is, that she says that she was sexually harassed and that there were other issues on set, not just for her, but others that she witnessed. He said no. And if I'm Lively's team at this point, I might I don't know if I would get the right to sue letter or if I would want to see what the California Civil Rights investigation comes up with. I don't know. I don't know what I would choose to do as the lawyer in that circumstance. Not sure. They go on to say the same falsified stories she had calculatingly devised and used throughout the production of this film in order to take control were now being used publicly to destroy Baldoni and plaintiffs. Look, we'll see how this strategy works. If they do not have quite a lot of proof that those accusations and allegations made by Lively are not true, two things might be true here, and it might backfire on them. It could be true that she took over the movie, that she wanted him in the basement, that she didn't want to be with him on the red carpet, that she fired the editors. All that might be true. But if the other allegations are also true, this is just going to be a lot of litigation for mutually assured destruction. Because I don't know if we get, if anyone gets out of this clear except the lawyers with their billables. So when the lawyers don't look mad in the media, it's because they're just like, let's go. So they go on to say Lively stole Wayfarer's movie, hijacked the premiere, destroyed plaintiffs' personal and professional reputations and livelihood, and aimed to drive plaintiffs out of business entirely. It further appears that Lively worked for months with the equally powerful New York Times to prepare a false and damaging narrative to deploy against plaintiffs. The New York Times is going to fight to say that's not true. We'll see. They're being sued too. Not surprisingly, Lively prepared an administrative complaint with the CRDC in an attempt to use the litigation privilege to shield her behind the scenes conspiracy with the New York Times. But upon information and belief, the CRD complaint was filed only after defendants spent months feeding falsehoods to the New York Times, intending that they should be disseminated to damage plaintiffs. I wonder how they knew that. I mean, they don't. They say on information and belief. They suspect that. Because I can't imagine anyone from the New York Times telling Baldoni's team at this point anything. Can you? I mean, I can't. They go on to say Lively on information and belief, they suspect this, leaked the typically private CRD complaint to the public. I mean, it was given to the New York Times. I mean, the same way Baldoni's lawyer gave voice notes or voicemails or voice memos to the media as well. Like, leaked is not what happened here. It was placed. Yup. Not that Baldoni's team hasn't also placed things. So, pot, kettle, all of you. It's the lawyers are just like, it's not like leaked implies that somebody at the California Civil Rights Division gave it to the media. That's not what happened. It's like when James Spears's team magically had all their filings with TMZ before they were in the public docket and before opposing counsel had them. That's what happens. Okay, we'll see. They say that they used the complaint to take revenge using the New York Times as a conduit for that revenge. The complaint, upon information and belief, which means this is their speculation, or this has been told to them and they can't prove it yet. The complaint, upon information and belief, the false information delivered to the New York Times before the CRD was filed, is rife with lies and doctored quote-unquote evidence. They say Lively then waited 11 days to file suit against plaintiffs in what seemed to be a desperate move after the public questioned why she had never filed a civil lawsuit. I mean, we talked about a right to sue letter, but okay. On information and belief, they're going to say this a lot. Just read, y'all, this is allegations and shade. Read all of this as allegations and shade. Read all of these complaints as allegations and shade. And the question I will continue to ask is, if this is true, then? Because on information and belief is we don't have the evidence yet, but this is what we believe is happening. On information and belief, Lively never intended to file a civil suit, which would have triggered plaintiff's right to discovery, including obtaining evidence and deposing Lively under oath. Well, she did. And if you sue her, she still has to, all of that still has to happen. By the time Lively actually filed 11 days. Oh my God, the horror of how long it was. Like the shade. By the time Lively actually filed a lawsuit against plaintiffs, the damage to plaintiffs was done by virtue of Lively's months of colluding with the New York Times. I think that's probably true. The shit's out of the horse. And they say that that was a malicious narrative unshielded by any privilege that goes directly to defamation. Make no mistake, these actions were deliberate. I mean, there was an immediate response to Baldoni, right? Lost representation, lost or had a award withdrawn, podcast co-host left, all those kinds of things we've seen reported. Though it doesn't seem that anyone's reputation at this point is great. Plaintiffs now have no choice but to fight back armed with only the oh, I'm sorry. I didn't realize I needed my narrator voice. Plaintiffs now have no choice but to fight back armed only with the truth and the mountain of concrete evidence disproving Lively's allegations. Heartbreakingly, a film that Baldoni envisioned years ago would honor the survivors of domestic violence by telling their story with the lofty goal of making a positive impact in the world has now been overshadowed beyond recognition solely as a result of Lively's actions and cruelty. Anybody work at Audible, by the way, or Calm? I'll do sleep stories. I've got you. I should read this entire document, the entire saga of documents as a sleep story. They go on to say, Lively wields immense power as one of the world's best-known celebrities. In 2024, she used that power to seize control of the film It Ends With Us, produced and co-financed by plaintiff Wayfarer and directed by Baldoni, who also portrayed the lead Ryle. And you guys have told me it's Ryle. My brain reads Riley. I will try. You guys were so helpful with sounds like Kyle. Perfect analogy. We've heard all of this packaged differently against the New York Times because they spent most of the New York Times lawsuit saying Lively did all of this and the New York Times published it. Like that's the New York Times. That's the New York Times in a nutshell. She set out to destroy plaintiffs' livelihoods and businesses if they did not bend to her incessant demands, and when they refused to give way. She did exactly that, accusing them of foul and reprehensible sexual misconduct. Wayfarer was blindsided when Lively, upon the conclusion of the industry strikes, refused to return to production absent the companies agreeing to her non-negotiable protections for return to production. Look, Lively's team said that they had repeatedly asked for things to be changed. And I think if that's true, that'll all come out in discovery. Those are the types of requests you would expect to see in email. And if I don't see those requests in email, then maybe I'll raise an eyebrow about it. But in that complaint, they said that Wayfarer had rebuffed repeated requests. So we'll see. Again, a lot of this stuff will come out in discovery, and there's a lot of people on a movie set. A lot of this will come out in discovery. They go on to say Lively's exclusion of Baldoni from the promotion of the film backfired, as she chose to callously promote her hair care and alcohol beverage products rather than bringing attention to survivors of domestic violence. The entire, I don't think anyone's going to fight about the marketing of the film being good. I mean, maybe there are. I'll see in the comments if there are. I don't think anyone's going with the marketing of this film was great. I think there were definitely some questions. I think people were just like, what are we doing? And I've seen a lot of people in the comments say more or less that it felt like this was marketed like Barbie, and people who hadn't read the book went to the movie and were like, wait, what am I watching? And I think that that's a very fair criticism. I think it's interesting to see the Sony document saying that that's what they decided that they wanted the marketing to be. I have a lot of questions about how that all came about because it was strange. Like, who thought that was a good idea? They said they wanted to focus on resilience, but it seemed that that's not exactly what the marketing was giving. They say that Baldoni, now prohibited from attending events or taking photos with Lively and the cast, promoted the film as he had always intended ever since he first began the process of making the film years ago. Again, there is documentation from Sony saying that they had a marketing plan that it seems that Baldoni agreed to. I wonder if Baldoni's going to turn around and say, well, we had no option but to agree because we were being extorted by Lively, which is what they seem to also be saying about the PGA mark that we saw in the other lawsuit. I'm trying to remember exactly which one, but I don't know. So we saw that in others. It goes on to say that Lively faced significant public backlash from what was often referred to as her tone-deaf and insensitive press tour for the film. She doubled down on her false and misleading accusations against Baldoni. Not in the press tour? Did that happen in the press tour? She seemed determined to make Baldoni the real-life villain in her story. Her publicist, Leslie Sloan, they say, went so far as to propagate malicious stories portraying Baldoni as a sexual predator, quote, a term Lively's husband, Ryan Reynolds, also used to describe Baldoni when he called Baldoni's own agent. I have questions. Also, based on everything we've seen alleged, it seems like that is a very strong phrase to use. Unless there's stuff we haven't seen based on everything we've seen alleged. It seems like strong language. Modern society justly reviles sexual harassers and abusers. And Lively knew full well that making those allegations would be a career death sentence for plaintiffs, especially given that Baldoni has lived his private and public life as an impassioned advocate for gender equality and healthy masculinity. She did not expect, however, that plaintiffs would be able to meet those allegations with concrete documentary evidence disproving her claims and demonstrating that they, not Lively, were the targets of a calculated and vitriolic smear campaign. And that is the heart of all of this. Really, whose PR team did what to who? And it's all going to play out in litigation. And this is going to play out in litigation for years. For years. The evidence included in part herein, we might have to zoom to the end or cover this more fully next week. We might have to do it twice. The evidence included in part herein is the basis for plaintiffs' claims against defendants for their extortion, defamation, and further wrongdoing. Okay, we're on page 5, paragraph 9. I'm going to zoom. I want to see what the causes of action are. So hang with me while we get to causes of action because this is 179 pages and I want to know where those are because I want to see what they're actually suing for before we continue to read this. Emily, we can't read the last page of the book. We're going to look at the causes of action when we find them. What page am I on? 53. Okay. Just put the Jeopardy noise in your head. I'm sure it's copywritten, but like that's what my brain is doing. All right. Where are we in our scroll? 80. Okay. Great. Do complaints need to be this long? No. Am I seeing a lot of similarities as I'm scrolling to the New York Times complaint? Yes. Is there going to be Overlap? Yes. Is there more? Yes. Is there a lot about Lively in here? Yes. There's a lot of pictures. I mean, I'm not mad at a lawsuit with pictures, but we're seeing some of the same text messages that we saw. I'm gonna do this with you guys. I'm just gonna keep it in a small window, but we're still not at the causes of action yet. We're 149 pages into the shade, and a lot of the stuff we saw in the New York Times lawsuit, like a lot of the same things we saw in the New York Times lawsuit, but we still don't. What are our causes of action? No. Law nerds, when you say, Emily, don't we normally get to the parties on like page 2? Yes. Where is that listed in this lawsuit? Page 168. Page 168. Until we get to the actual heart of the lawsuit. Plaintiff's Wayfarer, plaintiff's Baldoni, plaintiff Jamie Heath, plaintiff It Ends With Us Movie LLC, which is the company that was producing the movie, or one of them, Melissa Nathan, Jennifer Abel, defendant Blake Lively, defendant Ryan Reynolds, Leslie Sloan, Vision PR, jurisdiction, venue, they're saying New York. There we go. First cause of action, civil extortion. Oh, I haven't pulled up the rules in New York for a long time. I don't know what their page limits are. First cause of action, civil extortion. Defendants made threats to plaintiffs that they knew to be wrongful, including threats to breach contracts, defame plaintiffs, and injure. There's a footnote to this. Lively has contended that California law applies to any dispute involving plaintiffs or the film without conceding that Lively's statutory claims are properly brought, and with reservation of all rights and remedies, plaintiffs assert their claims under the substantive laws of the state of California. Just attach all the contracts so we can look. I want to know. I want to know. Just attach the contracts. Lively asserts that California law applies, though they're suing in New York. I'm so curious about the thought behind some of this. Defendants' threats included demands that money, property, services, or other sources of value be conferred upon defendants without consideration or contractual entitlement thereto. Plaintiffs complied with the wrongful demands. Plaintiffs were harmed. Defendants' wrongful threats and demands were a substantial factor in causing plaintiffs harm. So, first cause of action, civil extortion under California law, which I'm not going to recite for you by top of mind, but I'll pull up real quick. Let's see. We pulled this up in the Jay-Z when he filed as a John Doe against Busby. We pulled up civil extortion and talked about it very, very briefly then. But essentially, the elements of civil extortion are the defendant knew the threat was wrongful. What does this mean? That's element one. What does that mean? Well, it means that as this case goes forward, they are going to have to litigate all the underlying issues to determine if there was extortion here, because it's going to be like a defamation case. You are going to have to prove that the defendant knew that the threat was wrongful. The threat included a demand for money, property, or services, and that the demand was complied with. So they laid it out there. So is this civil extortion in California is going to rely on whether or not, well, it's going to rely on what was said, and what was demanded, and whether or not they knew it was wrongful. So that's the civil extortion. And they were saying they complied, essentially like under duress, and they were harmed because of that. Second cause of action, defamation, Lively, Reynolds, Sloan, and Vision. So these are against Lively, Reynolds, Sloan, and Vision. Vision PR, not Marvel Universe character. I know it gets Hollywood. Defamation. Defendants made one or more statements to persons other than plaintiffs, including without limitation to the New York Times. So instead of just suing the New York Times, hey, the things you told the New York Times were defamatory. And the New York Times published it. And you knew it was defamatory when you said it. And this is defamation against a public figure, acting with actual malice, which means you have to get to the heart of you knew that this wasn't true or recklessly disregarded that this wasn't true, which just CEG my entire video on the New York Times lawsuit. Just that's all there. They go on to say that the statements made by defendants were intended to and did have the effect of exposing plaintiffs to hatred, contempt, ridicule, or obloquy. Are we switching? No, this would be defamation under California law. Interesting. Or causing them to be shunned or avoided, or having a tendency to injure them in their occupations. Specifically, the persons to whom defendant made the statements reasonably understood the statements to mean that the plaintiffs engaged in permitted and or failed to prevent sexually inappropriate conduct toward Lively. So that's what it is. They are saying the allegations and accusations of sexual harassment on set are defamatory because they are not true. Third cause of action, false light, invasion of privacy. This is going to mirror what was laid out in the New York Times suit, which is kind of same. Excuse me. So defamation and false light, invasion of privacy are both in the California suit. This is under California, which is going to the false light or false insinuation. Like if the false light being that now people look at, if this happens, that people look at Baldoni and go, oh, wasn't he that guy that sexually harassed Lively? It's leaving that wrong impression. And regarding the PR agents, oh, did they engage in this smear campaign? Are they just tearing people down, et cetera, et cetera? So that's the false light. Fourth cause of action, breach of implied covenant of good faith and fair dealing against Lively. You did not act the way you should act on the movie set, and we are suing you for it. You did not operate in good faith. You did not operate with fair dealing. Fifth cause of action, intentional interference with contractual relations against Lively and Reynolds. This goes directly to WME. It was my understanding that WME put out a statement saying that this had nothing to do with it. But if WME comes out and says, we've had multiple complaints about him, it's going to go badly. So we'll see. But they're saying that the contractual relationship was Baldoni's relationship with his agent, and that they intentionally interfered with that relationship with their agent, and that plaintiff was harmed because of that. Intentional interference with prospective economic advantage, similar, because that is the relationship with an agent is an economic relationship. So those are similar causes of action for the same behavior. Negligent interference with prospective economic advantage, again, same with a different standard. So those three are synonymous, if you will. They are asking for a money judgment representing compensatory damages, including consequential damages, lost wages, earnings, and all other sums of money. An amount to be proven at trial, but no less than $400 million. Well, how much did this last movie make? Are they going to be able to make the sequel? They own the rights to the sequel. So will they be able to do that? And then money judgment for mental pain and anguish, severe and serious emotional distress. No IIED, no intentional infliction of emotional distress, no negligent infliction of emotional distress. I'm like, well, if we're going, let's go all the way there. Why not? Demand for jury trial. And then we are at page 179. So let's get back to, what were we on? Page 9. Let's see if we can get us back to page 9. Will that help us? Is that where we were? Let's get us back to the top of this document. Yeah, this is about where we were. Oh, page 5, paragraph 9. There we go. At least now we know what they're suing for, which includes, well, extortion, which is interesting. It's an interesting, that's what they keep saying. They keep saying it's extortion, so we might as well. You're right. Page 5, paragraph 9. Footnote 1. The film was hotly anticipated adaptation of the worldwide best-selling book by Colleen Hoover, and by starring in it as Lily, Lively stood to enhance her already considerable star power, but she was not content merely to headline one of the year's biggest movies, instead apparently driven by overweening ambition. That's a choice. And need for control, Lively eventually leveraged her power as a wealthy celebrity to wrest the reins from her co-star and the film's director, insisting on total control over every aspect of the film she could get her hands on, from wardrobe to marketing strategy to music, even creating her own cut of the film. I have so many questions about all of this. Footnote 1. It says overweening. I don't know what they, I don't, hold on. Well, I don't know. I don't know if it's a typo. Let's see. Somebody had a thesaurus. Overweening. Dictionary.com.
Overweening.
Indeed, overweening. Look. For all of you getting ready for Onyx Storm, not that kind of weaning. Different overweening. Law nerds, I know where you're at. Law nerds. And I mean fair. It's what we're all reading at the moment. But not what they meant.
Overweening.
Overweening, according to dictionary.com, is showing excessive confidence or pride. I mean, how does this play with hubris? Aren't we like same? I always learn something new. Is this a word I had ever heard in my life? No. Is this why I question whether this was written by a scriptwriter or a lawyer or both? Like, what? Where are we at with hubris? I don't know. Excessive pride or self-confidence, arrogance. Was hubris not enough? No, we had to go to overweening excessive confidence or pride. Hubris would have done, but no, not a minimal weaning and overweening. I'm I guess hubris wouldn't have worked. Yes, you're right. Hubris would not have worked in this context because it is a noun. Thank you. Rhapsody in Blue did say hubris is a noun, overweening is an adjective. I mean, yes. Way too much weaning. Devious One said, what's the right amount of weaning? I think it varies by person. If you're into that sort of thing, it varies by person. Some people are like, never. And some people are like, all right. Not to make light, but also when the lawyers bust out the thesaurus, we need to follow. It's very, for all the English majors in the room, there you go. Let's see. Footnote 1. In an early meeting with Baldoni, Lively foreshadowed what was to come. Oh, God. There's foreshadowing. It is. There's foreshadowing. The drama. Oh, my legal writing was clearly far too simple when it was just like this, that, therefore this. But again, not billing for how long it takes me to write a complaint, so different interests. In an early meeting with Baldoni, Lively foreshadowed what was to come, stating, I'm afraid you have too much power. Referencing Baldoni's dual role as producer and director. He was also the lead actor. It's a lot of roles. This statement made an early impact on Baldoni, who felt compelled to reassure her the relationship would be collaborative and went above and beyond to make it so. This was not an invitation to sideline him and his producing partners. Okay. I mean, it seems a lot to be producing it, directing it, and starring in it. But I'm not an expert in Hollywood. Goes on to say Lively eventually leveraged her power as a wealthy celebrity to wrest the reins from her co-star and the film's director, Baldoni, insisting on total control over every aspect. I still have a lot of questions about this because it's not just Baldoni. There are so many there are others involved. There are like the production company is a corporation with others involved. I have questions. I have questions. Not only did Lively's power play cost numerous people their jobs, but at every turn, her wrong-headed creative decisions reflected her fundamental lack of understanding of the book the film was based on. This came as no surprise to her worried colleagues, given that even well into production, Lively had not even read the book. Footnote 2. We've seen the lawyer for this group of plaintiffs say that repeatedly. What does this have to do with? Okay, I get footnote 2. Lively later claimed she read the book, but text evidence shows that well into production she had not, and in fact expressly expressed she had chosen not to read the book. She even tried to Google the color of her character's hair rather than pick up the book. This is just pure shade. Just pure shade. Just pure shade. Pure shade. September 14th, 2023, text message from Baldoni to Heath. Purportedly. Well, a part of it. This is a snippet of a text message that we were rooting to see her fulfill after reading the book, which had 150 pages to build their relationship. We have combined scenes to heighten the stakes for Ryle in pursuit of Lily, utilizing humor and his desire to sleep with her. While I understand Blake's reason for not wanting to read the book does a very good job in getting in Lily's mind during her interactions with Ryle and setting up the why behind her attraction to him, which ultimately helps us understand why she stays in the end. I mean, okay. Or she's friends with the author, and so they had that. Okay. That's just not legally necessary in any of this, but okay. Sure. The chat was like, but she would have read the script though. Yep, would have read the script though. Lively's disastrous marketing efforts and tone-deaf press interviews and appearances backfired and led to widespread criticism of Lively's promotional approach to the film's highly sensitive focus on domestic violence. Past videos of Lively resurfaced online, videos that appeared to solidify public perception that Lively was an insensitive quote-unquote mean girl who cared more about peddling her products than acknowledging the domestic violence survivor community. Social media commenters quickly pointed out her tie-in of her alcohol beverages, which was in very poor taste, given the World Health Organization estimates 55% of domestic violence incidents are linked to alcohol. Again, this was in the other lawsuit as well, and I imagine we're going to see a lot of duplication from the New York Times lawsuit. They go on to say, unbelievably, Lively made this harmful and irresponsible message worse by naming a drink at her premiere party after Ryle You Wait. After a character who committed domestic violence in the film, the suggestion that Wayfarer caused the online backlash against her is absurd given the evidence of her own insensitivity. Their whole argument is she wrecked it for herself. Like she wrecked herself in the things that she was doing. And I have questions if that was her choice or not, but we'll see. Let's see. They go on to say, sadly, this backlash could have been avoided had she not refused to meet with the film's domestic violence partner organization, nomore.org, as Baldoni had offered. Even a brief visit to their website or a simple online search would have readily uncovered this and other information on the topic. It also seems that others involved in marketing this movie should have been like, this seems like a bad idea. I don't, again, how did Sony not say, hey, this is our marketing plan, and somebody go, hey, this seems like a bad idea? And maybe Baldoni did, and he was completely shut down. We'll see. Meanwhile, they say Baldoni, whom Lively herself had insured, was excluded from from participating in her marketing efforts, was safeguarded from this backlash as he focused on amplifying the voices of those affected by domestic violence. And Lively's team said in their filings that the cast and crew didn't want to be around Baldoni, and that Baldoni's team created a messaging to explain that. And it wasn't because of his behavior on set. It was because he was focused on amplifying the voices of those affected by domestic violence. And Baldoni's team would say, no, he was excluded because Lively was on a power trip and the rest of the cast was afraid of her. There are two very, very different and very different sides of this conversation from the two different sides that we've seen. I want to see the third parties in the middle. They say Baldoni's sincere efforts were well received, even more so in contrast with Lively's campaign to downplay the premise of the film and sell hair care and alcohol products. Lively, enraged that her plans were foiled and armed with proof, quote unquote, of alleged sexual harassment in the form of a 17-point list of demands she had required plaintiffs to sign just months earlier, focused her rage on Baldoni, blaming him for the consequences of her own missteps. They say, meanwhile, Stephanie Jones, founder of Jones Work LLC, Wayfair, and Baldoni's erstwhile PR firm, was embroiled in a personal and professional crisis. And that lawsuit was fascinating. If you haven't watched me break it down, it's why that stream ended up being like 5 hours long or more, because that lawsuit was fascinating. Stephanie Jones was like, they're plotting behind my back and they went on a PR smear campaign to destroy me. And those text messages seemed more pointed in that lawsuit than some of the other ones. The other text messages that we've seen have multiple interpretations. The do you know there's a kill piece coming out on you? Mwahaha. Those text messages seem a little bit more pointed. They say Jones's behavior grew more and more bizarre as she lashed out at loyal clients like Wayfair in rage-filled rants and veered, all the angry women, right? And veered away from professional experience and strategy when making critical decisions affecting Jones Works clients. Did you just say she was too emotional to make good career moves? Okay. After a final outburst against Wayfair in which she outright refused to comply with their direct instructions, were the direct instructions that she not tell Sony she wasn't the leak? Were those the instructions? We've read that whole lawsuit. That lawsuit was wild. We'll see. Wayfair had no choice but to cut ties with Jones and Jones Work rather than leave their public image in the hands of what appeared to be an out-of-control Jones whose actions were not aligned with Wayfair and Baldoni's worldview and wishes. And then she said the Birkin was for her client and she kept it. They go on to say on information and belief, Jones, Lively, Reynolds, and Leslie Sloan, Lively's publicist, and others concocted a plan whereby Jones would seize Abel's phone upon her departure. Oh, so now everybody's in on Abel getting fired. The text messages with Abel do seem to indicate that Abel was planning to take clients and company documents before she got sued. I'm very interested to see how Lively and Reynolds are involved in any of that. Because this, I'm very curious. They go on to say, in a footnote, while it is not entirely uncommon to request that an exiting employee return company property, it is not often the case that personal phones, phone numbers, and communications are seized, made public, and weaponized against the employee and the company's own clients. Though Abel did seem to be taking proprietary documents based on all the text messages, but we will see. Because yes, employers do download your, and can download your phone. If it was a personal phone, I've got more questions. If it is a work phone, that's one thing. But if it's a personal phone that you use for work, they can still get your text messages. Ask Trooper Proctor all about it. He'll be happy to tell you how deeply they will go into all of your text messages. But they say that this was a conspiracy from the beginning to get the text messages from Abel, and that Jones was involved in all of this, and that's why Jones was left out of the smoke in the New York Times and Lively's retelling of this. They go on to say Lively claimed Baldoni was the one smearing her. In reality, it is Lively and her team who planned and implemented a vile smear campaign against Baldoni and Wayfarer to deflect attention and blame for Lively's disastrous misjudgments. Lively would recast herself as the long-suffering martyr by portraying Baldoni and Wayfarer as her persecutors, the masterminds behind a smear campaign that evidence will show did not exist. Show me. Interested to see. Shortly after the film's premiere, the public backlash against Lively, together with her husband, defendant Reynolds, demanded through their talent agency, which also represented Wayfarer and Baldoni, that plaintiffs publicly apologize for so-called mistakes during production in order to deflect the avalanche of negative media coverage of Lively. Reynolds and Lively drafted a statement and demanded that Baldoni, Wayfarer, and Heath issue that statement. I mean, I imagine there would be emails about that too. Requiring them to apologize to the public and fall on their sword despite having done nothing wrong, or else the gloves would come off. Multiple WME executives, again, WME being a talent agency, one of the big three, and well, they have multiple offices, but in Los Angeles, CAA, WME, UTA, those three agencies kind of run quite a lot. Lively and Reynolds' threats were not to be taken lightly. Though admitting to false, vague, and unspecified mistakes would be tantamount to admitting career-ending misconduct, Baldoni, Wayfarer, and Heath refused to apologize for sins they had never committed. They took a stand, knowing full well that Lively and Reynolds would
bring the jury.
Wait, that's not what it says. Would bring the full might of their celebrity artillery against them. And that is precisely what happened. So, we have gotten to they're doing what they say I'm doing. Like, no, they're doing what they say I'm doing. This is going to take forever to parse out. This is going to take forever to parse out. But the public's going to parse it out and forget about it before we even get to discovery. So it's just, I think we're really at mutually assured, messy destruction. They say Lively, working with her husband, her publicist, and Jones, among other things, set out on a campaign to tar and feather plaintiffs in the press. They conspired and worked in concert with the New York Times to put out a blockbuster news report as devastating as it was false. They advanced a fabricated narrative in the press that plaintiffs had sexually harassed Lively, then embarked on a calculated and malicious smear campaign to destroy her reputation as retaliation for daring to complain about the harassment. Well, that does actually summarize what they said pretty well. I think that is a fair summary. I would go a step further and say that they really alleged that the smear campaign was so that when Lively came forward, no one would believe her and be like, yeah, but she's mean, so we don't believe her. So They go on to say defendants laid their trap carefully over a period of months before springing it all at once on the eve of the winter holidays. Just as plainly, they knew full well that their claims were entirely baseless because their own wrongfully obtained quote-unquote evidence proved that neither the alleged sexual harassment nor the accompanying smear campaign against Lively ever existed. So, I think we will see a cross-complaint in the Jones work litigation, continuing to say that the forensic download of Abel's phone was improper. And I think we'll see a lot of fighting over that. I think that we will see a lot of litigation there. Oh, I didn't realize that the LA fires were going to come into play in this. Okay, here we go. I guess so. They say, yet Lively moved forward with her plans with ruthless precision, doubling down in the face of abundant evidence, casting doubt on the veracity of her story. Lively even went so far as to serve her lawsuit on the Los Angeles-based defendants as they evacuated their homes in the midst of devastating fires engulfing their cities. On a day when defendants were gathering their kids and pets, preparing go bags and monitoring evacuation orders while fearing for their homes, Lively, from the safety of her penthouse in New York, deployed process servers in the midst of these troubling times. Okay. I mean, I understand the frustration. I understand the, hey, this is insensitive. Also, when the subpoenas are issued, I will say lawyers generally send the subpoenas to the process server and say, we have 21 days to serve this. Can you serve it? I've never seen someone, and maybe it happens, specifically say, go serve them at this thing. That's generally just up to the process servers. Go serve it when you can. However, lawsuits are allegations and shade. So the process servers, by the way, process servers and repo are just like, I don't give a fuck. Process servers want to get the job done and move on to the next job. So I can see process servers saying, everybody's going to be home. I can absolutely see a process server say, everybody's going to be home. I don't know where they'll be if they evacuate. If they evacuate, we might not find them in 21 days. I can see process servers doing that. For all of you in the chat saying, like Witness said, do they not understand service of process? The lawyers understand service of process just fine. The public might not. And it goes on to say, look at how insensitive. Look at how insensitive. Look at how mean. I mean, that's why it's in here. How cruel to serve them while they are preparing go bags. That's what this is in there for. But you know, can I 100% see a process server say, if all these people evacuate, we're not going to find them in our time period? Sure can. And then I could see Baldoni's lawyers saying, this whole lawsuit is just filed to save face. They didn't even serve us. Can I see that happen? If Lively doesn't serve Baldoni and the defendants in the amount of time that is required, can you see the lawyers turning around and saying, this isn't even a real lawsuit. They didn't even bother serving us. This is all fake. This is all to save face. Like at this point, you're damned if you do, you're damned if you don't. Do I attenuate a lot of shade to it? No. It's just allegations and shade. At bottom, this has come up a lot lately. And in my brain, I'm just like, apple bottom jeans, boots with the fur. At bottom, this is not a case about celebrities sniping at each other in the press. Chat, tell me if you agree or disagree. This is a case about two of the most powerful stars in the world. Wait, I'm sorry, wrong voice. Sorry. Wait, I can't hear myself. My in-ears were like, no, girl, stop it. This is not a case about celebrities sniping at each other in the press. This is a case about two of the most powerful stars in the world deploying their enormous power to steal an entire film right out of the hands of its director and production studio. Then, when Lively and Reynolds' efforts failed to win them the acclaim they believed they so richly deserved, they turned their fury on their chosen scapegoat, tolerating a year and a half of their behavior while remaining polite and professional at every turn, offered Baldoni and Wayfarer no protection. So, the two sides of this are they use their power and influence to steal our movie and run a smear campaign. And the other side of this is shit was inappropriate on set. When I said something, they set out to destroy me to cover for the fact that the crew didn't want to be around Baldoni. The only way we're getting to the truth of this is through the crew. That's the only way we're getting to the truth. I'm not going to go through Baldoni and Wayfarer because I have like 3 minutes. I'm not going to go through Baldoni and Wayfarer purchasing the rights to It Ends With Us. It's lined out in the New York suit, and we can go through it more fully. I will also put the link to this lawsuit down below so that when we cover this in detail, if you guys want me to go through every email, every this, that, and the other thing, we will. But I'm not going to be able to go through all of it because I'm not going to be able to go through all of it. This is the purchase of the film, including emails. We know the film was purchased. Nobody questions that the film was purchased. Pre-production, Baldoni and Lively began a promising and close collaboration. Look, it was all great until it wasn't. Lively even felt comfortable to make silly jokes, redirecting a sweet compliment Baldoni gave. Just going to say, has anyone responded to something and then later went, why did I respond that way? Why was I trying to play nice? Why was I trying to keep it even? Am I saying that's what's happened here? No. Am I saying that I can envision that happening? Yes. Yes, especially when people feel vulnerable. They don't always respond in the way you think they will. It's like, but the response wasn't what I expected. Sometimes people do that. So we'll see. Lively begins asserting control almost immediately. She began inserting herself into the production process in intrusive ways well beyond the scope of her contractual entitlements. I want to know what happened here to allow this. I want to know what happened here to allow this to continue on. Like, if this was before all of the allegations of harassment, then it's before any alleged blackmail. Then how did this not get stopped there? I again, same thing. Was it that this is Baldoni responding like, oh, I guess it's okay? I don't understand how this got so out of hand. Like, how did we get here? If this is before any supposed blackmail, is this them accommodating an actress to the point that the ball's rolling down the hill and there's nothing you can do as it's picking up steam? Or is this, oh my God, we love how involved she is? And then down the road, they went, well, fuck. I don't know. We're not going to find out until later. And we haven't seen Lively's legal team really address this because it wasn't the heart of the harassment and smear campaign conversation. So we haven't seen them address that. We'll see. So did little accommodations get out of control? I don't know. I agree with you, chat. All of the chat is like, we need to hear from Sony. Yes, we need to hear from Sony and the crew. And again, Baldoni's side is going to say the crew all unfollowed Justin because they're afraid of Blake Lively. That's what Baldoni's side says. And it's insinuated by Lively's side, the crew all unfollowed Baldoni because they were uncomfortable with how he behaved on set. It's a very difficult dynamic. And Baldoni's side is saying the power dynamic is with Lively, Reynolds et al. And Lively's side is going to say they were the producers and they put millions of dollars behind this and said they'll spend $100 million to ruin her. We'll see. I still want to know how they know that. I want to see what they say about Reynolds. So they say Lively began asserting control almost immediately. Look, we're not going to get through all of this. This is 20 pages in of 179 with a lot of text messages. Will I talk about it in quick bits? Yes. Will we link it below for you to read? Yes. Ooh, Sony Legal Affairs. Friday, August 9th, 2024. Hi. We certainly need some clarity on public comments made about Ryan Reynolds potentially contributing writing services for the rooftop scene. Can you provide additional information on this? As there are no contracts, his services are not in the chain, nor is his name anywhere in the credits. One of the many media reports which cite this claim made by Lively, linked, thanks for clarifying. If services were rendered, obviously we require signed documentation immediately. And again, I wonder if this was Lively puffery. If this was just like, and I said it before, is this a rewrite? Is this Lively giving or receiving scene direction from her husband? And then she's like, and he even wrote a scene. Like, was that all bullshit for the media of like how involved he was that had incredible spin out? I don't know. Let's see. This clearly became an issue with Sony Legal Affairs. Hi, the email was shared with me by so-and-so in order to address this issue. We are not aware of any writing services rendered by Ryan Reynolds. Regardless of what is being said publicly, this is not something we are aware of. We are learning about these allegations in real time. Please let me know if there's any questions. Like, there's process for all of this. Sony's legal is like, the fuck are you saying? They say Lively and Reynolds raised entirely false allegations of fat shaming against Baldoni, an accusation that, as evidence will show, was categorically false. And then this is all, we got all of this in with the New York Times as well. We're zooming to the high points. Filming begins as Lively builds her takeover strategy. More text messages. But it seems that they extracted Baldoni's phone as well, because these look a lot like a forensic report from Baldoni's phone. So they have extracted his phone as well. Some of these are screenshots that were in the New York Times. Some of them aren't. And we're going to learn a lot more about that. I will, again, summarize it when we get to quick bits. During labor strikes, Lively moves to seize absolute power. That is a recharacterization of what happened in the New York Times suit, saying she required them to sign all this stuff and they agreed under duress. Forensic extractions. I'm interested to go through all of those. It ends with us confidential. We've seen emails in this before saying, I won't resume filming until we have these things in place. Baldoni's team has said, look, these were already in place. This just makes us look bad. So because it's already in place, we're going to say, sure, that's already in place. Let's see. We haven't gotten to how Reynolds is looped into this, but we're going to have to. Unfortunately, I am 5 minutes behind my hard stop. We are going to link this down below. I am going to cover it more. We're going to probably have to do another stream on this. I'll let you know if we do a stream on this on what day. It just depends on what happens over the weekend, but I will let the members vote. I appreciate you for being like, no, let's take a look. What do we know? Let's see. Here's what we know so far from our first look into some of the Baldoni versus Lively Baldoni versus Blake Lively, Ryan Reynolds et al. Lawsuit. Again, Baldoni's side is saying that all of this would have remained quiet if Blake hadn't gone to the New York Times in an effort to destroy Baldoni. Lively's team says it was Baldoni's team and PR that were seeking to destroy her in retaliation for allegations of sexual harassment on set. Baldoni's team said that is all made up and it was used as extortion to take control of the movie. In New York, Baldoni's team et al. Has sued Lively, Reynolds, and more for extortion, for defamation, for false light, for interference in contractual relationships, and for no less than $400 million. Yes, this is also in New York federal court. This is a 179-page complaint that is written so it can be read dramatically by the media, but it clearly lays out their side of how all this went down, and it mirrors the allegations they leveraged in the New York Times defamation suit, saying that all of this was contrived, that this was a ploy, and it was a ploy to seize control. We will see what the responses to all of this are, and I will have to go through the rest of it because we did not get all the way through this lawsuit. So there will be more to come because we are just getting into the emails, the text messages, the cell phone extractions of it all. And that will have to wait till QuickBits and next week. So make sure you have the Law Nerd app because that's where I'm going to keep you in the loop on all of this. And the lawsuit will be linked down below if you want to take a look for yourself. We are a long way from figuring out what happened in this. And, well, I'm interested to see what happens from here. Aren't you? Law Nerds, thanks for being here. I'm sorry that we have not gotten into all of this. I know it's hard to, when we're like, I'm so curious, it's difficult to stop midway through, but I get it. Colleen, thank you for the gift of memberships to everyone else who gifted memberships. Thank you. Redondo Beach said, this old lady officially applied to go to law school. Look, we got some claps in here. Hold on. I just have to find where they are because they're hiding. Look, congratulations. Very, very excited for you. And for everyone, we've seen lots of you this week embarking on new journeys. You should do audiobooks. I know I keep telling people this. I'm like, look, calm, where are you at? I'll read sleep stories. Legal documents as sleep stories. I got you. I need to just keep putting them up on the like sleep story legal channel. I think I'm going to change the name of that channel and just put up our historic documents as sleep stories on YouTube. So we have them. I mean, because I think it's amazing. Elizabeth said, thank you for the stream. I'm a PhD student with ADHD and I'm trying to quell an anxiety attack. Sour candies. I have come to you to re-regulate. Good. Also jump up and down. Your brain, your heart, and your humor are so grounding. Thank you. You're welcome. Sour candies, like the warhead ones and like jumping up and down, unless your foot is jacked like mine, but those things help me. So sour candy, jumping up and down. So I get it. K Skills said, as an actor, it's embarrassing for her that she didn't read the book, especially if she's friends with the author. The book gives you, she said hastily, script gives you lines and scene setting, no depth. I think K Skills, that's a very fair point. It's strange. Rebecca Wright said, it seems odd an actress could force a director to the basement unless he was scared because he acted inappropriately and was trying to appease her to keep quiet. And his side will say he was trying to keep the peace so this would all blow over and so the focus would stay on the movie. So we're going to get both sides in all of this back and forth. But I get it. And people are going to say, well, if she was harassed on set, why didn't she walk away from the film? And people are going to say, but if he was being extorted, why didn't he call her off or call her out and kick her off the film and reshoot? And that gets into quite a lot more discussion of, but then do the crew lose their jobs? Then does the production company lose millions that they've already sunk in? Then are there contracts that have to be met? I think there's a lot more information here that we need to know about. And hopefully we'll get to it. So Law Nerds, with that, I will see you soon. Stay tuned to the Law Nerd app. And if I do anything on Instagram, any reels, any breakdowns of this stuff, I will also link it in the Law Nerd app. And keep you in the loop because I'm sure more is going to happen this weekend. We'll see what happens with TikTok. All right, I'll see you soon. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop because you never know when something's going to pop off. Thanks for being here and thanks for being a Law Nerd.